Good evening and welcome to the September 14th, 2022 meeting of the Arlington County Board of Zoning Appeals. This meeting is now in session. The Arlington County Board of Zoning Appeals is also known as the BZA. I am Lindsay Arthurs, chair of the board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Judy Freshman and board members Inta Malice, Portia Clark, and Richard Kaplan. Judy Freshman is attending via Teams for personal reasons. Also present are the professional staff, including Blake Bowen, Board of Zoning Appeals Coordinator, Megan Ryan, BZA Associate Planner, Stephen Rissy, Zoning Prim Supervisor, and Patty Petrosini, Assistant to the BZA. This is our first in-person meeting in over 2 years and our first hybrid meeting in the history of the BZA. We ask that you give us considerable grace as we learn to navigate our new technology and our new format. Before we call our first case, I will share with you some general information about the BZA and then some ground rules on how we're going to conduct our hybrid meetings, or how we would like them to. We're still figuring this out. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend regulations set forth in the ordinance. That authority rests with the county board. The board does have the authority to do 3 things. We can approve use permits to allow modifications of placement requirements of structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from specific requirements of the zoning ordinance, and we can decide appeals on the decisions of the zoning administrator. Now, here are some specific instructions about this evening's hybrid meeting. First of all, please silence your cell phones, virtually and in person. Applicants, if you are attending in person, when your case is called, please move to the podium in the front of the room and identify yourself. Please be sure to speak into the microphone for the benefit of those on Teams. Speakers, please move to the podium in the front of the room when you are called upon. Please be sure to speak into the microphone for the benefit of those on Teams. Applicants and speakers in person, please note that the podium is adjustable. Tonight's meeting is also available to stream via the county website and Microsoft Teams. If board members, presenters, or speakers attending via Teams lose internet connectivity during the meeting, please reconnect with us by phone. If you are attending or viewing via a Teams link, please keep your phones and devices muted until you are called upon. Please turn off the sound on any devices around you to minimize interference. For those of you joining via Teams, please turn off your video feed until you are called upon to speak. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located on the meeting command bar in the top right corner. The moderator does not have the ability to unmute you. The meeting chat is active for presenters and board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the recording during the assigned public testimony period. For applicants and public speakers, you will be called upon by the county staff probably usually by me, at an assigned time. We requested that all speakers pre-register to speak tonight. If you did not pre-register but wish to speak, speaker slips are in the box on the front table, and you can hand your speaker slip to Megan on your left. If you're attending via Teams and wish to speak but did not pre-register, please speak to Megan, or you're not going to be here. How are we going to deal with people that didn't?
I would just ask that they ask to be identified when the case is called.
Yeah, if you're attending via Teams and you wish to speak, please just raise your hand and we will see what we can do. We will do our best to accommodate additional speakers if time permits. Public comments will take place only during the allotted time frames. During public comment, a speaker timer will be displayed on the screen and on the podium. You will be muted when your time is concluded. Please be respectful of the time allotted. Lastly, this is a public forum. Today's meeting will be recorded and posted on the county website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. After your case is heard, you're welcome to stay for the balance of the session or leave at your convenience. We will not hold it against you if you don't want to stay for everything. Now for tonight's meeting procedures. The staff reports for each case on tonight's agenda can be found on the BZA website. A link to the agenda can also be found in the chat section, as well as a QR code on the front table where you can view it on your phone. A limited number of paper copies of the staff reports are available on the front tables. We have those?
I believe, Meg, you have those?
Just kidding, Meg has them. If you've not seen the report for your case, you might want to review it before your case is called. Supplemental material has been turned in after the staff reports were prepared for a majority of the cases for tonight. There's a separate link on our agenda site for that material. The order of our meeting is as follows. First, cases will be called and board members will ask any questions they have of the county zoning staff. Next, applicants or their representatives will be given an opportunity to make comments in support of their application. Then, if they're speakers, they will be called upon at that time. After we hear from speakers for or against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any speakers, but we do not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for applicants and speakers to be sufficient. 5 minutes for applicants for use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all the information we need and has discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. This concludes the introductory remarks. Mr. Bowen, you're calling cases. Will you please call the first case?
Yes, Ms. Arthurs, would you still like to consider a group motion for the BZA?
Yes, we would.
Okay. Prior to the start of the meeting, Ms. Arthurs indicated that there was 4 cases that the BZA was interested in doing a group motion for. I will now read those case numbers as well as the advertisement language. The first case number is V-11772-22-UP-1, a use permit request by John and Mary Martha Churchman, the owners, to permit a street setback of 20.4 feet to the porch instead of 21 feet to the porch as required regarding after the fact approval for a porch on a corner lot in the R6 zoning district on the premises known as 1001 North Manchester Street within the Dominion Hills Civic Association. The second case number is V-11775-22-UP-1, a use permit request by John Monteith on behalf of Stephanie and Glenn Lee, the owners, to permit a rear setback of 16.6 feet to the wall, 15.6 feet to the eave instead of 25 feet to the wall, 21 feet to the eave, and a right side setback of 7.7 feet to the wall instead of 8 feet to the wall as required, regarding a rear 2-story addition to an existing one-family dwelling in the R6 zoning district on the premises known as 4206 8th Street South within the Barcroft Civic Association. The third case is V-11777-22-UP-2. This is a use permit by Mark Sterney on behalf of Rekia Ayalor, the owner, to permit a street setback of 22 feet to the wall of the addition instead of 25 feet as required from South Grant Street, a right side setback of 8.3 feet to the wall to the addition and to the porch instead of 10 feet as required, and an aggregate side yard width of 9.4 feet instead of 18 feet as required in the R5 zoning district regarding a new 1-story addition with rear porch on an existing one-family dwelling on a corner lot in the R5 zoning district on the premises known as 647 23rd Street South in the Aurora Highlands Civic Association. The fourth and final case for the group motion is V-11779-22-UP-1, a use permit by Rachel Callahan on behalf of Gerard and Jaime Simon, the owners, to permit a right side setback of 4.4 feet to the proposed window well instead of 5 feet as required regarding installation of a window well to an existing one-family dwelling in the R6 zoning district on the premises known as 4653 5th Street South within the Barcroft Civic Association. The staff recommendation for all 4 of these use permit cases is for approval as advertised, subject to the conditions.
Is there anybody who wishes to speak on any of these cases before we take a vote? Fabulous. Does anybody have a motion?
Madam Chair,
Yes,
I have a motion.
go ahead.
I move to adopt the attached proposed resolutions for the following four cases. V-11772-22-UP-1, V-11775-22-UP-1, V-11777-22-UP-2, and V-11779-22-UP-1.
Anybody like to second?
I'll second that motion.
Thank you. Is there any further discussion? I will call the roll. Ms. Freshman,
Aye.
Ms. Malice,
Aye.
Ms. Clark,
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to grant the application passes by a vote of 5-0. That concludes those matters. Mr. Bowen, will you call the next item?
Yes, Smith Arthurs. The next case is a carryover case. This is case number V-11765-22-VA-1. It's a variance request by Kevin Flum on behalf of Paula Cordero Salas, the owner, to permit a total lot coverage of 44% instead of 40% as required regarding a new second-story screened porch and landing on a pipe stem lot in the R6 zoning district with an existing non-conforming total lot coverage of 43.94% on the premises known as 6248 23rd Street South. 6248 23rd Street North within the Leeway Overley Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the variance request. An alternative resolution to grant the variance request with conditions has also been provided should the BZA see fit to approve the variance request as advertised. Please note there is supplemental material received for this case that came in after the application packets were assembled and printed.
All right, does the board have any questions for the staff?
I do.
Yes, I do.
Please.
I'm sorry.
Ms. Malice?
Mr. Bowen, do you have any background on this project, how this residence came to be built oversized?
We were not able to find any particular rationale, no previous BZA actions that created a lot coverage at present. Cannot really speak as to how it came to be. We did see within the application materials that a certificate of occupancy was granted for the house, meaning that at the time of its construction, it was deemed to have met all the zoning ordinance requirements. It may have been an error, but we don't know why specifically.
Did you examine the building permit to see if what was built was actually what was permitted?
The certificate of occupancy would be the indication that everything that was built matched the plans that were submitted.
I just wonder, in view of this unusual situation, whether a double check might be in order.
And I will say that I don't know for certain that the building permit plans are in our possession. I believe they are only kept for about 5 years.
Okay. And I could also ask the applicant, but it seemed like in the applicant's justification, they were the first residents of this property?
That I'm not sure of. I think they may have purchased it from a previous owner, but they can speak to that.
Okay. And
Mr. Kaplan?
My question is, what was the effective date of the current lot coverage ordinance?
I'm not sure of the specific date or month. I believe they were last updated in 2005.
That's good enough. Thank you. One more. Is how often how often does this type of a thing do you see happen? Is this pretty rare?
I will say that I don't, in my experience, I have not seen it happen often, but I don't know if that's necessarily a representative sample.
Okay, good enough for me.
Madam Chair?
Yes.
So this is another question for staff. Does the fact that there may have been an error grant the applicant any unusual rights?
I wouldn't say necessarily it grants them any unusual rights other than the fact that they would be able to maintain an existing non-conforming lot coverage without increasing it, where they otherwise would not be allowed to have that lot coverage.
Though we, in the zoning ordinance, there are cases where it's non-conforming that they are not allowed to, permitted to replace, they can only maintain. Is that correct?
Yes, correct.
Okay. Thank you.
And this instance falls under that?
They would be able to maintain the deck as long as the alterations that were made or the repairs that were made were not structural in nature.
Legal non-conforming. Okay.
Yeah, and that's a general, we haven't seen, specific plans or done a specific analysis of that beyond the BZA application here.
Interesting. All right. Is the applicant with us in person or online?
I'm online.
Hi.
Hello.
You
Sorry,
can
go ahead.
go ahead and speak.
Okay, thank you. And thank you, everybody, for reviewing our application. I'm Kevin Flom. My wife, Paula Cordero, I think is also joining from her phone from the car. She was coaching a soccer game. So I'll be doing most of the talking, but she might jump in to answer any specific questions. So I just wanted to take this opportunity to add a little bit of additional context, including the motivation and history of the project. Some of this actually touches on a few of the questions that you had. So, first, just to give you our motivation, for what it's worth, when we moved into this house in 2018, we had fairly quickly realized there are a couple of issues that made it a challenge for us to comfortably use our deck. Besides having a problem with mosquitoes in the backyard, certainly a lot more than in the front. We think due to some rain drainage issues that we've had, we've also got a number of large trees in our backyard, which ensure that our deck is always a mess. And in particular, a couple of those trees are large walnut trees. So starting around mid-June all the way through November, we have the joy of having to dodge falling walnuts on our deck. So, to help reduce the tree debris and minimize the walnut issue, we've trimmed the trees back as much as we've been advised that we can safely do. But we haven't gone so far as, and we don't want to go so far as to cut these trees down. These are large old trees that, add value to not just our property, but our neighbors. One of the trees is actually in our neighbor's property, not ours anyway. So for us, covering the deck, screening it in is going to help solve our tree debris issue as well as our mosquito issue. But in order to screen in the deck, the existing deck actually has to be replaced because its current design doesn't support the addition of a roof, which would be needed to screen it in. And since we needed to rebuild it anyway, we had initially proposed enlarging the deck in our original proposal from earlier this summer. However, that's when we were informed of the non-compliance issues with not only our project, but with the property as it is now. As I think you just touched on, when we purchased the house at the end of 2017, it included the current deck and the lot coverage of 43.94% at the time, which is above the 40% allowed by ordinance. But it wasn't until we started this process that we learned that we actually had a problem. After we had purchased a house, we got the certificate of occupancy that was granted on January 3rd of 2018. And I believe that the certificate says that the property complies with all the provisions of the Virginia Uniform State Building Code and the Arlington zoning ordinances. So we didn't realize we had a problem until now, basically, until the summer. When we learned of this problem, we decided to defer coming before you. We were scheduled to come a couple months ago in order to take another look at our project. What we decided to do was to shrink the project so that we were no longer enlarging our footprint from what it was. So we're still requesting a variance, but we're actually keeping the coverage at the same coverage limit that it is now, the 43.94%. And we also at the time, took a look at some of the proposed solutions from staff. So one of the proposed solutions was to potentially reduce the size of our driveway, which is actually one of the reasons why we have such a high lot coverage. We're on a stem lot, so we have a pretty lengthy driveway. Obviously, we can't shorten the driveway. The driveway is 9 feet wide, so there's no prospect of narrowing it. The most natural or obvious change we could make is eliminate the parking pad that's on the driveway, but the parking pad is used by us and by visitors and delivery trucks to turn around in our driveway so that you can exit it facing forward instead of backwards. Would very much think it's necessary to keep that because right now the lot in front of our house is vacant. It's inevitable that there's going to be, a property built there and it's going to completely block off visibility from the driveway. We can't readily expand the front porch because the front door of our house is actually on the second floor of the house. So, we attach some photos. You'll see it would be a pretty major construction project to try to expand that. Expanding that would, allow us to cover 43%, but in fact, even at that point, we wouldn't have enough overhead basically to be able to do this with the deck. We would still be in non-compliant, so it doesn't get us where we need to be. So, our last resort is to request this variance. I just want to be clear that we're really not asking for an expansion, 40 to 43. We're just asking to do this project on the current footprint, which is 43. And I realize my time is basically up. So just want to say we appreciate your consideration, and I'm happy to answer any additional questions that you might have.
That is a very aggressive beep. I'm sorry.
It's effective.
If you want to finish, please feel free. That was very aggressive.
No, I mean, that's it. I mean, I just want to say that, we don't believe that, this construction is going to have any impact on the adjacent properties. And by doing this, it's going to allow us to sort of, preserve the land, the yard as it is, not cut down trees and so on.
All right. Does the board have any questions for the applicant, Mrs. Matlis?
Yes, I'm not sure that this is entirely relevant to my decision here, but I am trying to understand your statement that you are the first ones to occupy this house.
We are. So our understanding of the history of the house is it was built or started to be built, I think, in 2007. The builder for the house subsequently passed away, and the property then became, the property of his 4 adult children, who are the Claibornes, I think is their name, who own the 3 adjacent vacant lots to our house. So there's letters of support or emails of support, I think, from them. So they were the owners. I'm not entirely sure why it took them so long to sell the house. I think there was just a lot of disagreement amongst them about, what price to sell the house for and so on. But ultimately, when they did sell to us in 2017, we were the first buyer. So we were the first people to move into the house, which is why at that point, the house got the certificate of occupancy.
Did you guys build the house in its current state, or was it built when you purchased it?
It was built when we purchased it, yeah.
Thank you.
Any other questions?
Was there any support provided by your neighbors at 6252 or across the street at 6247?
I believe, yes. I'm actually not sure which addresses those are.
Hello, this is Paula. Sorry, I'm going home, but yes, we did get all surrounding neighbors support, and also across the street. So yeah, the five properties. And I want to add that it was this house was built and was vacant for a while, and it was built as it is with the 43.94% coverage, and we were the first ones that moved in. And after we purchased the house was when the certificate of occupancy was granted, and that's what we believe that at that point that everything was in order because we were provided that.
Any other questions? Are there any speakers? No. Anyone want to make a motion?
Yeah, I'd like to just speak to this a minute. Absent any additional information from staff on this, given that proximity in time to when the lot coverage was revised, it's possible that this was approved under the past lot coverage rules. That it was, the building permit may have been, because we don't have a date for the building permit, right?
If the building permit was not acted upon, it would have expired and it would have then therefore had to have been reapplied for in all likelihood. So it's not necessarily likely in my mind that the building permit is from pre-2005 with the old coverage
We
requirements.
just don't have that history.
There are, the tax records show that there's 2 building permits that were pulled. I think they're still open in 2013.
2013, okay, so, all right. So I guess, I think this is unfortunate, but it's very similar to, in my mind, what's happened to a number of houses where the lot coverage rules changed and caused certain houses to be non-conforming, and when they go to make alterations, they find that they cannot replace, they can only repair. And so unfortunately, I think this is very similar to a case that we find frequently. And so I'm not inclined to, well, I'm inclined to support staff's recommendation. And I'd be happy to make that motion.
Go for
Not
it.
happy, but.
I'm sorry.
Right.
Before you
Okay.
do that, with all due deference to my esteemed colleague, I come down on the other side, and my computer. I think that this case is distinguishable from the common case that you're referring to, because this applicant bought this house thinking that the building permit was either issued or should have been issued, right? I mean, they were allowed to move into the house, so I assume that they would have assumed that the building permit was issued under the current zoning regulations. So they, for all they knew, they could have wanted to do this porch when they bought the house and would have been under their rights to assume that, because the house was built in 2013, which they would have assumed would be under the new building code and the new coverage requirements. And as I go through the requirements for a variance, I interpret them to fall under each one of these items, right? So, for example, criteria 1, would the strict application of the terms of the ordinance unreasonably restrict the utilization of the property? I believe it would, because I think the terms of the ordinance should be applied to this property when it was built. So if this building permit was approved under the 40% rule, they would have assumed it was 40% and everything would be in compliance.
I disagree. That's we'll vote on it. But.
And then, so, I'd be interested to see where my colleagues are. And
I feel like the fact that they purchased, I mean, I think of a number of cases that we've had in the last couple of years where they're decks, brand new builds, the same spot, same situation, and their decks, even when they were falling down to replace, they still couldn't do it. So I think for consistency, it pains me to say it, but I don't think that I can vote for it in favor, because I think it would have to be consistent with what we've done in the past.
And I think that the only differentiating factor to me is that, they bought this house in 2013, assuming that the house was built under the current ordinance, right? This is not a case in which it was done under the previous ordinance and then you're stuck with the previous ordinance.
The only thing I could think is that, maybe we could defer and get more information on the building permit and see if that is actually the case, but I don't know that would change all that much. But I feel like we are absent a few.
I'm just one of five, right? So that's my opinion.
Ms. Freshman, would you like to weigh in?
Yes, I think that it's unfortunate that we don't have the correct information about the timing of the CO, the timing of the permit. I see it as very different from a case like we've had where builders max out and the purchasers lose out when they want to make any kind of a modest addition. In this case, that doesn't seem to be the case to me. I would see it as administrative error if in fact a CO was granted with that much of a discrepancy between what was approved and what we believe that the coverage requirement is, but without more information like that, that could maybe clarify this, I don't see it as analogous to some of the other situations we've had. And I would be inclined, if we're going to have to vote on it, to give them the benefit of the doubt, because it looks to me on its face like it's a county error, unless we can be proven wrong.
Thank you, Ms. Freshman. I just want to point out one thing, that in the packet of materials submitted to, I assume, by the applicant, on page 62, the very last page, we do have a certificate of occupancy, which is dated 1/3/2018. So right, this problem is even arising after the certificate of occupancy has been given, presumably under the current zoning rules.
But doesn't that suggest that if the coverage is supposed to be 40 and they issued a CO in 2018
Yes.
for
Yeah.
substantially more square footage, that it's not the fault of the builder or the applicant?
And I completely agree with you.
Madam Chair? Yeah, I'm still not persuaded. I don't think this is a case where the developer overbuilds and therefore the owner can't expand. I think this is a case where a property is non-conforming, and therefore the owners can only maintain, they can't replace. So that's what I'm seeing the analogy to, not that the builder maxed out the coverage. So to me, that's the analogy. And the question has been in my mind is, if an error has been made, do we perpetuate the error? And I was coming down on the side of that we don't perpetuate the error, that we recognize there was an error, but we move forward correctly.
How would we correct this error?
This property is non-conforming. And so therefore we treat it as not like we treat other non-conforming properties. I don't know if assigning blame to the builder or staff as far as how we got into the situation really changes the fact that today it's non-conforming.
Anyone have any other thoughts?
Have we had a case, or do we know of a case in which a building is non-conforming the day it was built?
We've had many cases where staff error has taken place, and we don't perpetuate the error. Where a building permit has been issued incorrectly. We've had garages, for instance, where the building permit has been issued incorrectly and the garage is halfway up. And now, they're coming to us saying, neighbors don't like it and they're asserting their rights. The owner is saying, but I got permission. And so, obviously it is that's a very, very difficult situation when there's an error. But I guess I'm taking a very strict view that this is, this property is non-conforming. And so therefore it should follow non-conforming rules. But it's not my intention to try to persuade you.
No.
I'm telling you where
No,
I'm coming out.
Does the alternate resolution change anything? Portions of the school portions. Oh, that has them building.
Sorry, Lindsay, was that a question for me?
It was just, it was to anybody. The alternative resolution has them rebuilding on the same.
I guess the question that we could ask, since staff has recommended denial, is what is their rationale for their recommendation?
Or proposal for the alternate.
So sorry, first question was our rationale for the recommendation of denial.
Yes.
I mean, I suppose it's, outlined in the staff report itself, but we just do not feel that it meets the criterions to the variance or hardship criteria in the state code in terms of being a hardship.
Yeah. So the alternate resolution just has them building unscreened porch and stair landing on the existing exact same spot, right?
Substantially similar, I think. Their plan is slight tweaking of the size, but it's roughly the same.
And not enclosing it.
And I think the alternate would be to approve,
Yeah, alternative would be to approve
as the plan is.
with lot coverage matching the current lot coverage, which is non-conforming, but not increasing it beyond that.
All right, colleagues, who would like to make a motion one way or the other?
Well, I'm happy to make a motion and see if it passes, and then we can try a different motion. In case number V-11765-22-VA-1, I move that the Board of Zoning Appeals deny the variance request as included in the staff resolution.
I'll second it.
Microphone. Is there any further discussion? All right, a motion has been made and seconded. I will call the roll. Ms. Freshman,
No.
Ms. Malice,
Aye.
Ms. Clark,
Aye.
Mr. Kaplan.
No.
Chair votes no. The motion, this is where I get confused. The motion to deny the application does not pass.
Yes.
Fails, right?
Yes.
Okay, on a vote of 2 to 3. So where shall we go from here?
You make a different motion.
Anyone else have another motion?
Madam Chair, I'll make a motion.
Thank you.
Let me get my bearings. I motion in the matter of V-11765-22-VA-1 to adopt the attached alternative resolution for approval as advertised.
Second.
A motion has been made and made by Mr. Kaplan and seconded by Ms. Freshman. Is there any further discussion? All right, we'll call the roll. Ms. Freshman,
Aye.
Ms. Malice,
No?
Ms. Clark,
No.
Mr. Kaplan.
Yes. Aye.
Chair votes aye. The motion to grant the alternative application passes by a vote of 3 to 2. Congratulations. All right, that concludes this matter. Mr. Bowen, will you call the next item?
Yes, Ms. Arthurs, the next item is the associated use permit for this application. It is case number V-11765-22-UP-1. This is also a carryover item, a use permit request by Kevin Flum and Paula Cordero Salaz, the owners, to permit a rear setback of 20.8 feet to the porch, 19.8 feet to the porch eave, instead of 25 feet to the porch, 21 feet to the porch eave as required, a right side setback of 17 feet to the porch, 16 feet to the porch eave instead of 25 feet to the porch, 21 feet to the porch eave as required, and a left side setback of 8.9 feet to the landing instead of 21 feet as required regarding a new second-story screened porch and landing on a pipe stem lot in the R6 zoning district on the premises known as 6248 23rd Street North within the Leeway Overlea Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. We did provide an alternative resolution of denial in the event that the variance application was denied, which it has not been. So that is probably a moot point right now. And as with the last case, we do have supplemental materials for this application, which included 8 photographs submitted by the applicants.
I think we've been down, no, Ms. Freshman, go ahead.
I just want to reiterate that this is exactly the same square footage as exists there now. Is that correct? Somebody?
Staff?
Yes, sorry. In terms of the lot coverage, I believe the different features included in the porch and the landings and the screened area are a little bit different than what exists now, in addition to the fact that it's covered now. But the square footage and the lot coverage work out to be 43.94 in both cases.
Thank you.
I think they asked for like an extra 5 feet for leeway or something to bring it up to 44. Is that, my memory's correct?
Yes, the advertisement was written with a little bit of wiggle room, as we do with some applications. It's only 0.06%. It's a very small square footage amount.
I just wanted to point that out for Ms. Freshman for the record.
Yes, correct.
Anyone have any questions or want to make a motion?
No speak.
There are any speakers.
Madam Chair, I'm happy to make a motion.
Okay.
I move that the Board of Zoning Appeals adopt the attached proposed resolution granting the use permit request with conditions in case V-11765-22-VA-1.
I'm happy to second that.
Thank you. Is there any further discussion? I will call the roll. A motion has been made and seconded. I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to grant the application passes 5-0. Now, congratulations, guys. This concludes.
Thank you.
You're welcome. This concludes this matter. Mr. Bowen, will you call the next case?
Sorry, my microphone wasn't on. The next case is case number V-11767-22-VA-1. This is also a carryover item, a variance request by William B. Lawson Jr. on behalf of Bradley and Eleanor Patute, the owners, to permit a main building footprint of 4,574 square feet instead of 3,920 square feet as required for a one-family dwelling with a qualifying front porch in the R10 zoning district, regarding a new one-family dwelling with front porch, attached garage, and rear deck in the R10 zoning district on the premises known as 4620 36th Street North within the Old Glebe Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the variance. An alternative resolution and conditions have been provided should the BZA see fit to approve the application as advertised. Please note that we have additional speakers who have signed up to speak on this item, as well as supplemental materials that have been submitted after the application packets were printed and assembled. One of the supplemental materials includes a request by the applicants to defer this case to the November 2022 BZA hearing.
All right. Are the owners or the applicants here, or Mr. Lawson, would you like to speak?
Yes, thank you, Madam Chairman. On the last case you just heard, I bet you it was approved by the county board. There's a sleeper section in the zoning ordinance that says when you have a pipe stem and you want relief from setbacks, you got to go to the county board. So I bet you that's where it got approved. I met with an attorney for two of the neighbors about a week ago. And this is kind of at the foot of a hill, and there's been a lot of stormwater problems that this area of Arlington has experienced. And my client has had quite a challenge in attempting to address those. And a couple of the neighbors still think that we can do a little more work on that. And so I met with Mr. Lunger, and he asked that we defer it, and we agreed to. And I did a email to Mr. Lunger, and I'd like to share with you what it is we're going to do with this deferral. We're going to review the by right solution as recommended by staff as an alternative to the request for the variance. Even with a by right solution, should we find one, we will continue to address the client's drainage concerns and continue to work with DES. When I say the clients, I mean Mr. Lunger's. We're going to utilize a retaining wall on the front left of the house with a planter box. That will remove the drainage system running around the house and will pitch the grade towards the street. We will not extend the garage attached to the house, and that square footage may or may not be added on to a deck that is currently wrapping around the house. That was a recommendation by staff also. We have asked for we have a contact in our engineering firm, and we understand that they've had some engineers look at this, and we want the engineers to consult with each other and attempt to work further on solving the drainage issue. And that's pretty much the reason for the deferral. Like I say, there's been a lot of engineering work done on the storm drainage. One of our neighbors, Mr. Normile, has he said he had a flood in his basement, $100,000 of repairs. And my client doesn't want to have a drainage problem any more than they want the neighbors to have one. So that's the reason for the request, and we hope you would give us the additional time to solve this, which may or may not result in not coming back. But we aren't there yet. We still need to look at some things and work with the staff. Thank you very much.
Does the board have any questions?
So,
And Ms. Mallis.
how are you?
I am good.
When, if you come back with an increase, a request for increased coverage, or you're asking for lot coverage, right?
Yes, ma'am. It's main building
footprint.
Main
yes.
building
Yeah.
footprint. I think we need to talk about what that rationale would be for allowing, I mean, in new construction on a lot that's so oversized.
Well, there's a number of reasons why, and I'm not prepared to put the case on
Good.
tonight, but we now have stormwater stuff all over the lot. We have some covenants we have to work around. And we have not hit the percentage limit, we've hit the cap limit. And we're only going over by, I don't know, 500 feet, something of that nature. But we are looking at design changes. And so we think that instead of having an outbuilding, we think we have to attach it to the main house in order to allow the drainage. But if we come back, I'll have an engineer ready to explain.
Does anybody want, oh, well, there are some speakers. Would the speakers like to speak, or would you like to wait and see if you would like to speak at a different time?
No, I think the speakers should speak if they still want to.
Mr. Corcoran?
Can you hear me?
Yes.
This is Scott Miller, and I just want to note you have each adjoining landowner on. So Mr. Corcoran's on, and Mr. Normile, who was just referred to, I believe, is on as well. And I believe Mr. Normile filed to be a speaker, but somehow that didn't come through. So, but he is on, and all of us, I believe, would like to speak.
Okay.
That is correct. Brian Normile is here and would like to speak.
All right, whoever wants to speak, could they identify themselves?
Brian, do you want to start?
Certainly. I also additionally had filed some additional information on this case last night on the website, but it's not been passed out as a part of the case. The situation here that exists,
Could you
just
identify
quickly.
yourself?
Oh, certainly. This is Brian Normile. I am the adjacent property owner at 4614 36th Street North. Additionally, I own another parcel that abuts the property that the applicant has filed application for. To correct Mr. Lawson first, the extent of damage that incurred at my house as a result of flooding from overland water that came over the applicant's lot is well in excess of $250,000 of damage that happened from a prior storm. This is a situation where this lot has excessive drainage measures on it that the county must maintain to stop the groundwater that comes over this lot. So there is a 42-inch storm drain pipe that runs along the applicant's property where it abuts my property. And there are storm sewer inlets that collect a significant amount of water. So this is a lot that does have an existing drainage condition, and the applicant is well aware that problems have existed here. Matter of fact, the property that they purchased flooded prior to them buying it. I know the prior owner well. So we've got an existing situation here where there are significant drainage concerns with the existing permitted project that exists. So irrespective of this zoning application, which I'll talk about for a second, you've got a situation where the applicant is trying to solve concerns that are significant with the county, and the county staff is already working on this. But as it relates to the variance request, it seems preposterous that that board would consider approving 600 feet of additional coverage on this. It's already at the maximum footprint. And to make it any larger with the existing concerns seems preposterous. Thank you.
Ms. Ryan, is there a way to make it beep once or twice instead of keep going? Thank you. I think it's distracting to the speakers as well. Who would like to speak next?
This is Scott Miller. I'm the owner of the property with my wife that's above this lot at 4636 Street North. We have the distinction that we've never flooded. Every other home around here has flooded. The way the engineering was set up for this property, there's a levee system built in at the lot line that goes over 60 feet. And I've had to hire lawyers and engineers to try to get the owner's attention. So Mr. Lawson's representation that we're advanced stages of settlement is not accurate. And with the by right barn, it's a 22-foot barrier right where the runoff is that Mr. Normal talked about. And that must go downhill to county inlets. And they built this house not only across that runoff path, but they've set this barn in front of it too. And so we've had to bring lawyers, notices, other things here. We finally have county DES working. But when I look at this latest proposal, it's another levee system. And so I don't see how this meets the variance standards at all. And for it to be deferred in its current form, it raises questions to me why a determination shouldn't just be made that it doesn't meet the standard. And if they want to come back with something else with a new application, perhaps they should do that. But this seems so blatantly over what would be considered under the statute. It raises question to me why it should be deferred. We've been 10 months at this trying to get the attention of the neighbor and their engineers for a solution. I think allowing this just to roll out like this exacerbates the problem. I don't think it moves it to settlement like Mr. Lawson has represented.
Did you say your address was 4636? 26.
No, 4626 36 North. So I'm the corner lot above.
Yeah, I'm sorry, I misheard you. Thank you.
Yes, and I have two significant runoff patterns that go across the lot that have been misrepresented by the engineer for the builder as coming from an inlet in the street, which is not accurate at all. This has been to try and steer county staff the wrong direction, and DES has now recognized the true runoff pattern that is starting to kind of work this around. But this is not as cooperative and collaborative as what was represented earlier.
Mr. Miller, one more time, what is your address?
4626 36th Street North. I'm at the corner of North Abingdon.
So you're the adjoining, you're an adjoining neighbor.
I am an adjoining neighbor. Yes, I'm sorry if I didn't make that clear. Thank you.
I'm sorry. So who was the speaker before you? What was their address? I'm a little confused.
4614 North
Okay.
36.
So you're on the other side.
Yes.
Correct. And
Got
also, I'm also the abutting property owner in the rear as well.
The 3575?
No, there's an independent parcel without an address.
I see the outlot. Okay.
Right, that's it.
All right, thank you.
There's one other adjoining landowner who's here as well.
Okay, can you please identify yourself?
My name is Dan Corcoran, and my address is 3575 North Abingdon Street.
Okay, so
I
the
am
rear neighbor.
I'm the rear neighbor. Yes, ma'am.
Okay.
You can go ahead.
Okay. I'm Dan Corcoran. My wife, Leanne Corcoran, is probably on this call as well. She is doing carpool duty tonight. We abut to the property in question here at the back of the lot, and we have strenuous objections to this variance request for additional 654 square feet of coverage for two reasons primarily. We have concerns over stormwater runoff and its detrimental impact to our property, and we see no hardship. In terms of stormwater runoff, we've got a real issue here, as Mr. Miller and Mr. Normal have indicated. The water flows down from Glebe Road, from the church, through the neighbors' yards above me, through Scott, through the Patoos, and then into Normals. And this is the work that they're doing here is a significant impedance to that runoff. In terms of the hardship, we understand that that's an absolute requirement for these variance requests. And we have two easements on our property as well, and we do not find that to be a hardship. We have two utility easements on our property, and we still managed to do a sizable addition to our house a few years ago. Like everyone else, we made the trade-offs to stay within the county lot coverage, setbacks, and runoff requirements. It's not that difficult. There are rules for a reason to protect us all, especially with the increasingly significant storms we are having. Further, the Patoos decided to tear down the existing house on their property, clear-cut the lot, and design a house from the ground up. So their ability to stay within the county regulations has been 100% within their control. They've designed this house from scratch, so we see no hardship in these circumstances. I would also like to say that I object to an additional delay in this process. We've got the county write-up, the board, the write-up from the county. We've got the owners here. We've got the adjoining neighbors, and I think that I would like to see this settled tonight so that we can move on. If there are additional considerations, that we can consider those in a future time in a different application. Thank you.
Anyone have any questions for any of the speakers or Mr. Lawson?
Madam Chair, with regard to the suggestion that we hear this matter tonight and make a decision tonight, Mr. Lawson has requested a deferral and has indicated that he is not prepared to make a presentation tonight. So I would like to give him that benefit to at least prepare. I might ask why a 2-month deferral as opposed to a 1-month deferral, Mr. Lawson.
What happens with 1 month is by the time you get going, he needs to publish his report. And we think 2 months is needed. We're going to, have engineers talking to engineers probably and getting county stormwater staff involved. So I don't think a month will do it.
So it's possible that you may not return to us if you develop a by right solution.
Yeah, what happened is they had an original plan that was approved, and in order to address the stormwater, they shifted an outbuilding, attached it to the main building. That's what shot our coverage over the limit. And so they're looking at, are there other places on the building we can reduce coverage? Can we let it go? And so forth. So that's what they're looking at. They've started to look at that, and we'll also work with Blake on that.
So certainly from my standpoint, a by right solution would be ideal.
Okay. Thank you.
Thank you.
I'm sorry, I have a question before you sit down. Sir?
Mr. Lawson.
Oh, I'm sorry.
I'm sorry, quick question. This might be an obvious point, but if you return to the board, it might be likely that your plan is not going to be the plan that's before us, which is why we should not rule on this plan tonight. Is that a fair statement?
Say that again, I apologize.
If you return to us in 2 months, it might be a fair statement to say that the plan before us might not be the plan we
Correct.
would be before us in 2 months.
I think you can I think that's for sure.
And that's why, in my view, we can't vote on what's before us tonight.
I agree.
Yes, sir. Thank you.
Anyone have any other questions?
I'm prepared to
comments?
make a motion.
Fabulous.
In the case V-11767-22-VA-1, I move that the Board of Zoning Appeals defer this matter to our November hearing. And I don't know if I have a date for that. 9th? November 9th hearing. Thank you.
Any seconds?
I'll second.
Thank you. A motion has been made by Ms. Malice, seconded by Mr. Kaplan. Is there any further discussion? I will call the roll. Ms. Freshman,
Aye.
Ms. Malice,
Aye.
Ms. Clark,
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. Motion to defer the application to the November 9th BZA meeting passes 5-0. That concludes this matter. Mr. Bowen, will you call the next case?
Ms. Lindsay?
Yes?
There's Ms. Arthurs? I
There's
just
what?
wanted, before you call the next case, I just wanted to thank Mr. Lawson for advising us on the previous case. As we have more than one pipe stem just in this agenda, and it comes up more often than not, I think it's very useful and probably for staff as well to have been given a possible explanation for the wild discrepancy in coverage that we saw in that case. So I think it was very enlightening, and I hope everybody takes it to heart for future cases. Thank you.
That's a good point.
Ms. Arthurs, I believe the next case may be called by Meg, if she's willing to call it from her podium and has microphone access.
Yes. Case number V11768-22-UP1, a use permit request by Mary Curtius and Ori Nair. The owners to permit a left side setback of 15.3 feet to the side addition instead of 25 feet as required, a right side setback of 8.3 feet to the rear addition, 7.6 feet to the eave instead of 25 feet, 21 feet to the eave as required, and a rear setback of 21.0 feet, 20.5 feet to the eave to the rear addition instead of 25 feet, 21 feet to the eave as required regarding a new side and rear addition to an existing one-family dwelling on a pipe stem lot in the R6 zoning district on the premises known as 5412 26th Street North in the Yorktown Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. We do have one additional speaker that has signed up, and we have received supplemental material.
All right. Does anyone have any questions for the staff?
Ms.
Absolutely.
Chair, Madam Chair, can you describe the supplemental material? We should always put that in the record.
Yes, the supplemental material, we have 2 neighborhood outreach letters.
Anyone have any other questions?
I do.
Mr. Kaplan?
Mr. Bowen, can you speak to this case that has the neighbor's carport is encroaching on this property?
I may defer to Ms. Ryan on that question since she drafted and researched this one.
That.
I may chime in as well, though, with further information if I have it.
So based on the calculations provided by the applicant, they included some of the neighbors encroaching.
So the neighbor has an encroaching carport on their property, and that counts against them for lot coverage issues?
That's what they've included in their lot coverage calculations.
Is that what the county concludes?
Yeah, do you guys agree with that?
Right, if this property came to you and you were calculating lot coverage, would you look at the neighbor's encroaching carport?
I can chime in on that. Yeah, generally speaking, if an improvement is on the property within the parcel boundaries, we would count it towards that property's lot coverage. We see it sometimes with shared driveways. It's probably the most common instance where we see it, where a shared driveway counts towards potentially both lots that it's on.
Shared driveway this is not a shared carport? Or maybe the applicant can speak to this?
I do not believe it's a shared carport,
Yeah,
but
right.
the applicant can speak to that. Yeah.
So this seems to be like, again, another odd circumstance. Well, I don't know. I just know that in one of the supporting letters, I think from the agent of the applicant, they make reference to having to tear up the driveway, and we're unhappy with that. So I don't know yet.
I don't think coverage is an issue in the application, but it is interesting.
Right.
Are the applicants here? In person? Could you please come forward?
Wow.
Hello, I'm Mary Curtis. My husband Ori Neer is here also. We're the owners of the property.
Can you raise the podium can go up a little bit.
I'll come down.
And Meg, can you start her timer again? We're all still figuring this out. It's a new podium too.
That's fine. Ori's
Wonderful. Thank you.
Members of the Board of Zoning Appeals and county staff, I want to begin by thanking the county planning staff for their assistance and patience during this long application process. Throughout the process, Ms. Ryan and Mr. Blake have been responsive, professional, informative, and generous with their time, and my husband and I deeply appreciate that. My husband and I, with the help of our architect, John Weber, who's here and can answer your questions, I hope, have brought you a project that we believe is modest in scope, in keeping with the character of our neighborhood, and supported by nearly all our neighbors. Our goal from the outset of this process was to make only those changes to our 1964 home that are necessary to enable us to age in place. We have lived at 5412 26th Street North for more than 20 years. We bought our house before the county changed the setback requirements for pipe stem properties, and only learned of those changes a few years after they were adopted. There is simply no possibility of creating single-floor living in our home within the existing 25-foot setback requirements, which is why we are asking the board to grant us a use permit. Our roots in the Yorktown neighborhood and in Arlington County are deep. We want to stay in our home, in the neighborhood where we reared our 2 daughters and have bonded with neighbors and friends. To accomplish that goal, we would replace the aging wooden deck on the back of our home with a single-story, one-room addition that would have a smaller footprint than the existing deck. The addition would serve initially as a family room and, when needed, as a ground floor bedroom. We also would enclose the rear of our carport to create an accessible bathroom and small laundry area. Together, these changes would enable us to age in place. It also would extend the life of our nearly 60-year-old house by improving its functionality. No trees would be lost to construction. No shadows would be cast on any existing structures on contiguous lots. The rear addition would not be visible from the street and would be clad in siding that will match the existing second-floor siding. I have reached out to all my neighbors and to the Yorktown Civic Association, sharing all our plans with them. I submitted our plans in a PowerPoint presentation to the Yorktown Civic Association and spoke directly with the Civic Association President Michael Cantwell about the project, but have never heard back from them. Just this morning, our neighbor at 2527 North Jefferson Street shared with me the letter she submitted to this board yesterday opposing our application. I want to say that I am deeply disappointed that this objection was raised at the 11th hour and that our neighbor did not raise her concerns about potential damage to trees on her property with us prior to submitting her letter to this board. I received her email at 9:30 a.m., far too late to respond adequately to her concerns about the trees. I believe that her concerns about privacy are unwarranted, that our high windows on the west side of our addition would not impact her privacy. Ori, my architect John, and I believe that this project is worthy of your approval. We thank you for considering our application, and we're happy to try to answer whatever questions you have. Thank you.
Does anybody have any questions for the applicant? Great. Ms. Daniel, are you on virtually?
I am trying to get my camera to turn on here. That's me. Hi. Yes.
Hi. You can go ahead.
Oh, okay. So thank you for hearing the neighbor's request here, or my as being the neighbor of the request. So this really didn't dawn us until this weekend, and it was just through a conversation with my brother. So it was never intended to be a last minute reclama, and it is not to oppose it. It's just to request more information before considering the request for the construction. So I don't want to repeat everything. I sent in a letter that goes into detail of exactly what the concern is. So I hate to repeat things that people are already familiar with, but just for clarification, I will. And again, it just dawned us this weekend. We were looking into it. I didn't want to be an alarmist and worry about it without really knowing what it was about. So there are 2 trees in our yard and 1 tree in the near's yard that are they're all 3 of them are they're a variant of a Norway spruce. So they're very tall trees. They're 60 to 70 feet tall. They're large trees. And so the concern is, somebody pointed out to me, that they have no taproot. They are strictly a surface, and I'll get my notes here because I look all this up, but their roots develop laterally with approximately 30-foot radius, and they're very shallow within the first 4 inches of the soil. All the roots that keep those trees intact are from falling over, basically. And so this root system, it's my concern, I don't know that it would, but it was my concern that ours is approximately 10 feet from the proposed structure will be with a concrete slab, and theirs is approximately 5 feet from that structure. So the concern is that this construction will disrupt the root system. There's a large segment of the root system that will be under it, and the trees could then not have their, what's the right word, but they would unseat and could fall over, particularly in high winds or during wet periods. So that's our biggest concern, because these trees, being as tall as they are, it could contact any number of the homes around this region, which I don't need to go into the detail of, hurting life and limb and pets and all kinds of things, and needless to say, damage to houses. So my request is, because I see time is running out, but in addition to them falling over, we're worried about them being, if they didn't fall over, it could still damage the roots, so they get disease. And they're very substantial trees for the neighborhood, which are important. And I won't go into how much carbon and oxygen, all of that. But the request is that before agreeing to this use permit, that we get an arborist in to look at the trees and determine if the construction will have this impact on the trees, which just seems problematic to me. And I think it can be worked out. So I want to make very clear that we're happy to work with the neighbors. They've been very gracious and transparent with us, but it wasn't even really on our radar. Originally, we were concerned about the privacy. They very graciously decided to put up a screen of plants, or so they would put up a screen of plantings there. So I think it can be worked out. We just are now concerned about the trees, given their root system, and would like that request before coming through.
Madam Chair,
Yes.
can I ask the
Yes.
speaker a question?
Yes.
How much time do you feel you would need to contact an arborist and have them get out there and take a look?
I don't know, but I would think within a month that yes, that the nearest somebody could get an arborist here.
So you think in a month you would have a better understanding of the situation?
I would think so. I've never done this, so I hesitate to say anything with commitment, but yes, I would think so. You might want to, I don't know what Mary and Ori have, they're sitting there too, what they think, how long it would take them to get that kind of information.
Are you suggesting that they get the arborist, or were you going to get the arborist?
Well, I would think this would be my suggestion. We would both come to, to an arborist that we both think would be a good arborist. And I would hope they would call and get the information. Okay. I mean, we can do that. That's fine.
Okay. Thank you. I'd like to speak to the applicant again.
Mary, can you come back up? We have some other questions.
Ms.
Malice, go ahead.
What do you think of the proposal to have an arborist come in and examine the trees? Well, I mean, my immediate response was to start calling arborists today frantically after I found the email. And I did find a certified arborist who said that he could come out Monday and survey the property, but I didn't know at the time whether Ms. Daniels, I'm not exactly sure how this would work. Would this end up with dueling arborists, or would this end up, I don't really understand how this would work. Would I put forward my arborist, and if my arborist said one thing, should I
No,
want to have another arborist? I'm not exactly sure how this would work.
no,
Ideally, you know, as Ms. Daniels suggested, you would have an arborist that you both agree, you know, are happy
I
with.
would think any certified arborist would be fine with
He's
us.
a certified arborist, and when I talked to him, I said, what I would want is for you to come out and make an absolutely honest assessment, because of course, if there were any problem, the issues that Ms. Daniels raised of the trees falling over and crushing houses and killing pets or things, I mean, obviously, we have no desire to have that happen, and we could do that if, we can do that on Monday.
So our process would be to defer this item for a month so that you would have an opportunity to consult with an arborist, consult with your neighbor. Because, for instance, if the arborist says, you know, the construction will have no bearing on the trees, then that's one situation. The arborist could also say it could potentially damage the trees. So then, you know, there would be another conversation, right? What, you know, are there steps that could be taken to protect the trees during construction? Or if the arborist felt that there's no way the trees would survive construction, you know, what would be the alternative?
So I guess my question to the board would be, I mean, does that mean that the board is interested in approving this project with that condition? Or is this would then just begin the conversation, that you now have additional information about an arborist, that an arborist would supply, and then you would start your conversation about whether this is a project of merit or not?
So we cannot pre-approve a project.
We would defer for a month, have you guys work it out, come back to us.
But, you know, I can tell you from my standpoint, this seems to be, you know, the major issue. I don't see a lot of other issues right now.
Okay.
So I'm not sure that, you know, your concern that this is going to be a lengthy process is something you need to worry about. But again, you know, from your emails, you've been very cordial with your neighbors, and, you know, I expect that, you know, Ms. Daniels and you would maintain a very cordial relationship, and I'm sure she regrets sort of blindsiding you today. But if you can maintain that cordial conversation, I think we can probably get someplace.
So I will send Ms. Daniels the name and the contact of this arborist, and she can speak to him also. And I can share with her the questions I asked him. I took it straight from her email and said, these are the concerns she has. Could you please answer these questions?
Sure.
And I'll share that with her. And if she approves of it, I'll go ahead and have him come out Monday.
Yeah. So that'll be perfect. And again, I'm sure this will work out. We would feel a lot more comfortable with the information from a tree arborist.
Okay. So, but anyway, if there's no problem, that's one thing. If there is some kind of concern about the tree, then you and Ms. McDaniels would need to sort of work out what a solution might look like. And then we would take that into account. And if you're both happy, then, you know,
We're happy.
we're happy.
Thank you.
I think you guys want the trees to be intact anyway, because it also provides a significant amount of privacy for your house as well. All right, does anyone want to make a motion for deferral?
I'll make a motion.
Fabulous.
So it's to October?
Yes.
I'm just looking at the date.
October
12th. In the case V-11768-22-UP-1, I move that the Board of Zoning Appeals defer this matter for 1 month to our October 12th hearing.
I'll second it.
A motion has been made by Ms. Malice, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to defer the case to the application to the October 12th BZA passes 5-0. See you guys next month. That concludes this matter. Mr. Bowen, will you call the next case?
Yes, Ms. Arthurs. The next case is case number V-11769-22-UP-1. It is a use permit request by William B. Lawson Jr. on behalf of Kevin O'Brien, the owner, to permit a street setback of 17.9 feet to the existing main building, 15.9 feet to the eave, instead of 25 feet to the existing main building, 21 feet to the eave as required from the easement for public street and utility purposes for 18th Road North, regarding an existing one-family dwelling on a corner lot in the R6 zoning district on the premises known as 1808 North Randolph Street within the Cherrydale Civic Association. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions. Please note that we have additional speakers who have signed up to speak on this case.
All right, is there any supplemental material?
I do not believe we have received any supplemental material for this case, no.
That's amazing. At least for tonight. Does anybody have any questions for the staff?
I do. Do we know when this house was built?
Sorry, can you repeat that question?
Do we know when this house was built?
I do not know offhand, but I can probably pull that up for you very quickly.
I can bring that up too. Thanks.
Mr. Lawson, would you like to speak?
Is Mr. Randall listening in?
Who's Mr. Randall?
That's who is acquiring the outlot. I'll go ahead and speak to this. The staff has done a good job of sharing with you why they think this use permit should be granted. If you look at the plat that is attached to the staff report, the Randalls own Lot 1, and Lot 1 is surrounded by, they just have no yard. And so they are trying to acquire this outlot to have an area of their yard where they can utilize some, do some outdoor activity. And there's excess land and setback and so forth on Lot 3B. This is about the third time I think I've been in front of you all where a neighbor wants to enlarge their lot and another neighbor is willing to convey some land. In Fairfax, many years ago, there was an ordinance amendment to the zoning ordinance allowing it to be a boundary line adjustment, which is a pretty simple thing. Yeah. In Arlington, it's a lot more difficult. And so what we do is there's two ways to do it. One is to change Lot 1 and Lot 3B and create, Lot 1A and 3BA or whatever, or create an outlot which then gets conveyed. When we do make a lot smaller, some of you all may remember I had an appeal on this exact subject. Under the Arlington ordinance, when you make a lot smaller, there's a section that says everything else has to be in compliance with zoning. Mm-hmm. And so we have this one situation where we have the one front yard setback, which is when measured from the property line is a few feet lacking in the 25 feet. Arlington has recently been measuring your setback not from the property line but from the back of the easement for sidewalk street purposes. And I don't necessarily agree with that, but I'm not going to argue it. We have come in and sought relief for the existing house. Nothing's changing with respect to that for the setback from the back of the sidewalk. That's really all I had to say. We've done a lot of work on this. We've been out and seen neighbors, and as far as we know, there is no opposition, as far as we know. Thank you very much.
I have a question for the applicant.
Yes.
The there are neighbors that appear not to have been contacted, and they're marked in our staff report as being rental owners. I'm a little concerned about that, especially since one of them in particular is affected.
Which address? Where were they?
There's a chart in here.
I think the client,
towards the end.
knocked on doors and the occupants were unwilling. They just felt like they shouldn't
No,
sign.
according, right, as renters, but I would like to see the owners contacted. Because I think the owner that's adjacent would definitely be affected by the creation of that outlet.
You talking about the neighbor on 18th Road?
Yeah, to the right of the property.
Mm-hmm.
Because one of the questions I have is, and maybe you can answer this, the person that's acquiring the outlot, that property has an easement, a utility easement.
That's a private utility easement. Yes, ma'am.
Can they build over that?
I think so.
So
they can build like asphalt, tennis court. They can't put structures.
They can't put structures on it. So they could not build, in other words, it's creating a new rear line for that property, right? They could not build further back than they already have.
No. This is not to expand the house on lot 1.
Well, I understand what the intention is. I'm just understanding what the possibility is for but I am concerned that one particular neighbor would be affected by the creation of that outlet.
How do you
If you'd
think
like
they
for
would
us
be
to,
affected?
we'll be happy to send a registered letter to
I just
the address.
Because you typically, if you were to subdivide property, you wouldn't necessarily, they're not building on it. And you wouldn't necessarily go to your neighbors if you were subdividing.
So what happens is that, the potential for use of that rear area changes. And that's why I was asking about what could be built there. Right now, there's one neighbor that adjoins. Now,
I feel like wouldn't the only person that could build on it would be, well, obviously 3B because they own it, right? But they couldn't build in that area of the lot anyway because it's too close.
Well, as he said, they could build, they may not be able to build a structure, but they could build things on it. So I felt like that would be good for that owner to understand, and see the plans and know what was going to happen there, since it clearly abuts his property. That was my thinking there.
We would be happy to send a letter to that owner. I guess we'll have to use the tax records.
And so the instruction in the BZA guidelines, gives information on how to contact owners. And I know you know how to contact owners. So that's my only hiccup here.
Okay.
Anybody have any other questions?
We'd be okay waiting to the October meeting to do that.
I was just about to ask that.
But we should hear from the speakers as well.
Are the Kreiders here?
Hi, yes. There's only one Kreider. I'm actually John Christopher Kreider, so there's a duplication there. So thank you, Madam Chair and the members of BZA. I live at 1812 North Randolph Street, and if you go to page 6 of the staff report, that is directly across from the subject property. On the subject of the builder of the property 4105, the lot 1, I would suggest that the builder created the hardship by building such a large house and not leaving any front yard or backyard. So I'm not really sure that that while I appreciate what the Randalls are trying to achieve, and they're wonderful people, I've had many of their packages delivered to my house, and including a few meals that I did not want to send over. But and Mr. O'Brien's been a good neighbor, and I've trimmed his yard a number of times. But one of the things that really concerns me is that by allowing a subdivision to go through, you're taking the potential value of this property out. This house was built in 1925, and directly adjacent to it are three multifamily houses, and this is an excellent lot for that type of continued growth. As a neighbor, I haven't had any problem with the multifamily housing. Parking is not an issue, nor is noise. And so I think philosophically, this is a mistake to subdivide a property that will actually lose value. And it's a bad precedence because granting the variance is not necessary because either the house will be torn down eventually or redeveloped. And if you grant this variance, then a large house could potentially replace it at this shallower distance. And I believe that zoning at that time should prevail. And therefore, I don't really see any hardship that exists. The house is a non-conforming lot. No one objects to the location. They haven't since 1925. So the only purpose of requesting this variance is to allow the expansion to the rear of the Randalls lot, which I do not feel is appropriate given the area in question. And I don't really see any, as I said, any hardship to this. The other thing is that this lot is almost wide enough for two single-family houses. By taking this outlot out of the equation, you're reducing the potential in an area that's well served by transit and is very close to the Ballston corridor. So while I respect the desire for a backyard, I do not think that this variance should be requested or accepted or approved at this time. Thank you.
Did we determine that the house was built in the 20s? 1925?
Yes, Mr. Others,
1925, according to the staff report.
Okay, I think we can throw out the builder maxed out the lot point just because it's
No, the lot to the south, 4105, was built in 2020. There was a single family house on that lot, and they put 4 houses in, and it's an overly wide road. And the builder chose to orient the new house towards 18th Road North and rather than Randolph Street. So it took it completely out of its historic context and left a very, very shallow backyard and a rather large house.
Oh, okay.
That's for 4105.
I got confused. Okay, gotcha.
Madam Chair?
Yes.
Or this question for staff. Did 4105 require BZA approval?
I will look into that right now. I don't believe so.
I'm just listening to the applicant in terms of shallowness, or it's almost like a URD.
18th Street. All right, does anyone have any comments, questions?
So I have a question in the staff about what the rear setback is on 41. It's what the rear setback would be, because it looks very, if in fact it's oriented towards 18th Street, well, even if it's oriented to Randolph, it looks kind of shallow.
Ms. Malice, I'll do some research on that at the moment.
The house in question is 3B, right?
The house in question is,
On the subdivision.
Is 3A. I mean, 3A is giving up the land. 3A is giving up the land. Yeah. And in 4105 is gaining the additional, yeah.
The bigger house is gaining additional land.
Right. So I'm just curious.
The confusion is the plots are reversed on the between the two pictures. That's why I keep going back and forth on this.
Yeah, I was very confused. So the application is to create the outlot and change their setbacks on the smaller house.
The smaller house is giving up the land to the larger house.
The two are like swapping.
Yeah.
Yeah.
And so the smaller house is asking for the relief.
I thought the bigger house was asking for the relief, and so I was completely.
That's what I was with you. Right. I was with you.
But I'm now looking at the 4105 and I'm going, what was that rear set? What is the current rear setback? And maybe you can, well, I guess maybe Miss Arthurs, who can read drawings quickly, can actually say what the
Because I
rear
read surveys
setback-
for a living, is that what you're saying?
Yes, since you look at these plans all the time. I'm looking at any place where they actually give a number, but I don't see one.
Ms. Malice, can you repeat your question? I'm trying to follow along.
Okay,
Which setback are we trying to figure out?
so in the larger house,
3A or 3B?
Okay.
3A.
Lot 1.
lot 1.
Lot.
Well, wait a minute, no, you can't.
You can't do
So-
that. Yeah.
So the
It's
larger
approximately
house.
16
Okay,
feet.
the larger house, the speaker said is oriented so that the front is 18th Street and
Front is
the
18th.
rear is
Against
towards
outlet A.
Yep.
the potential outlet. And so my question is,
Yes.
what is the existing setback on 4105?
Miss Malice, I've pulled up a plat from, it looks like 2016, and keeping in mind that this is a corner lot, so there's two 25-foot street frontages, and then the rear would be a 10-foot setback requirement. And the
10-foot
side would
setback
be a
requirement.
8-foot setback requirement.
Got it.
And it looks like on the existing plat, it's exactly 10 feet.
And was it, so it would have been by right?
Yes, 10 feet would be considered by right.
All right, that would have been by
Interesting.
right. Because of the
rear yard
225s.
Sorry, staff, the rear yard setback is at least 16 feet where the easement is. The side yard that you just referenced is to the adjoining lot to the west, lot 2. So it's about 16 feet backyard.
Yeah.
I think staff is looking at a plat that says it's 10 foot. So the front of the house is 18th Street, so the rear, staff is saying the plat says,
Sorry, my my plat is oriented differently than the plat in the staff report, so
That's a 14.
let me re-evaluate that.
There's a 14-foot private utility
Right.
easement on the back
Oh.
of the property
Oh, well,
that is
this is-
adjacent to the proposed Lot A.
right.
Randolph
So I'm
is the
looking at the
front.
tax map.
Yes.
Randolph is not the front. The front
would
door
agree with
faces
this.
18th Street North.
So
And I'll just add that there may be a difference between what zoning considers the front of the property and what is functionally the front of the
just-
property.
You
Yeah.
don't
Oh,
have
he's
to,
talking about,
when you're on a corner lot, you can front the side. You don't have to front the front.
so, yeah, okay.
But
I'm-
the front
I'm
technically
with
is
you.
on Randolph, therefore your 10-foot setback.
You're
one
saying
abuts
the
lot 2.
front is technically
Adjoining one is
Randolph
at least
Street.
15.
Okay, then
Then
I'm
why
with
is it addressed for 18th Street North?
this is,
Well, zoning and
depends on your
the
definition.
address
Zoning
would
and
have to go
addresses are
together.
not always the
Front to
same.
front.
So the rule for,
Yes.
for
Okay.
what is the
That-
front
that's-
of the
this is
house
the
is
area
the
that's
Okay.
front
Is
of the
the
house is the
shorter-
narrowest frontage,
the
is
shorter
the
one.
front of the house.
Yeah. And you don't
Regardless
have
of
to-
where the entrance is or what the post office says for
That can be
zoning.
on the side. But
Yeah,
yes, that's
so
right.
reevaluating the plat at my initial assertion that what zoning considers the front of the property is North Randolph Street,
Right.
and the rear is therefore 10
10
feet by zoning
And
standards.
it has a side setback of more than 14 feet.
Looks like 16.8 on the plat I'm looking at.
That makes sense.
That, okay. Thank you. Thank you for orienting us. So,
Yeah. Now I'm square.
so so we're talking about 4105 having, will have a greater side setback, not rear setback. Okay. That's helpful.
Well, the lot, it'll still be its own lot. Because it's not, they're not combining Lot A with Lot 1.
Is that correct, Mr. Lawson?
I didn't catch that, I'm sorry.
So the Lot 1 is not being combined with Outlot A. The owner of Lot 1 will just own Outlot A. The setbacks on Lot 1 will stay the same.
In this instance, you're probably correct.
Okay.
There have been other instances where you get an outlot conveyed and then you re-subdivide and add it into the lot.
Right.
Because of that private easement, I don't think that'll happen, but I would have to talk to Mr. Randall.
That's, I don't know that that's material for our approval.
Yeah.
It is good for the neighbors to understand what the potentials are.
Yeah.
I don't think there's much.
But that was my title insurance hat for a second.
I've heard the concern of Mr. Kreider, and so next month I'll be able to speak to that.
Okay, yeah, touching base with Mr. Kreider would be a good idea.
Yeah.
Did we defer this yet?
We have not.
We're about to.
Yeah, I think we shall. Would someone like to make a motion?
I'm happy to, or if somebody
You're on a
else-
roll.
Okay.
I was bringing you, if you have it sooner, whoever finds it first.
All right, in the matter V-11769-22-U-1, I move that the Board of Zoning Appeals defer this item to our October 9th, 12th BZA hearing.
Second.
Is there any further discussion? A motion has been made and seconded. I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. A motion to defer the application to the October 12th BZA hearing passes 5-0. That concludes this matter. Mr. Lawson, we'll see you next month. Mr. Bowen or Ms. Ryan, can you call the next case, please?
Yes, case number V11770-22UP-1, a use permit request by Ken Reed on behalf of Miriam Anasari, the owner, to permit a street setback of 20.2 feet to the main dwelling, 18.2 feet to the eave, instead of 25 feet to the main dwelling, 21 feet to the eave as required, a street setback of 16.4 feet to the stoop instead of 21 feet as required, and a street setback of 16.6 feet to the window well instead of 21 feet as required, all from the 19th Street North, regarding construction of a new one-family dwelling in the R6 zoning district on the premises known as 4730 19th Street North in the John M. Langston Group. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And please note supplemental material for this case that came in after the application packet was assembled and printed.
Can you describe the supplemental material, please?
Yes, it was 5 neighborhood outreach letters.
5? Mm-hmm. Okay. That's a lot. Does anybody have any questions for the staff? Okay, that's fabulous. Is the applicant here in person or virtually?
I'm here.
Hi, Mr. Reed.
Good evening. I'm Ken Reed from RK Architects, representing the Ansari family. The existing house was built in 1987, and Mr. Ansari bought it in 1988. So he is the original owner of the house and a very long standing resident of the neighborhood. The Ansaris really love the neighborhood and would like to live there. As the family grew, they outgrew the existing house, which is only 3 very small bedrooms and 1.5 baths. And a multi-generational traditional family with grandparents, children, and grandchildren all living in the same house. The existing house is no longer able to suit their needs. So as a result, they've been renting out the house in recent years, but really would like to move back into the neighborhood that they grew up in. The existing lot is quite wide, but very, very shallow, only 74 feet deep, and does have the 5-foot public easement in front. And you remove when you subtract the public easement, you have 69 feet. And when you subtract the 25-foot rear yard and front yard over restriction lines, we're left with only 19 feet to build on the site.
I'm sorry, you're breaking up, and I don't think we can understand you.
Okay, I'm going to move a little bit closer.
That's much better.
The existing lot is only,
That's much better. Thank you.
Okay, the existing lot is only 74 feet deep, with a 5-foot public easement in the front. When you subtract out the easement, it leaves you 69 feet. And when you then subtract off the rear and front yard building restrictions, you're left with only 19 feet to build in, which is not even the depth to put a proper garage in. So our request is that rather than to encroach in the front to the extent where we would be as if our setback was from the property line rather than from the line of easement. That would give us a 24-foot buildable deep envelope, which with that, we actually can work with the house and create something that the Sari family can use and continue to live in the neighborhood.
All right, does anybody have any questions? I'm sorry, Mr. Reed, continue.
That concludes my presentation.
Okay. Does anybody have any questions for Mr. Reed?
Madam Chair, I have a question.
Yes.
I guess, well, for the owner, to ask why the delay in sending out the request to the neighbors. And it looks like one letter did come in, but there's also the presentation for the Civic Association has been requested, but was not done initially.
And the Historic Association as well.
Mm-hmm. There's two different.
Two different associations are requesting input.
Yeah.
Mr. Reed, would you care to comment?
I was not aware of the request from the Historic Association. The letters for the 6 neighbors did go all out at the same time, and we did receive confirmation of receipt of all of them.
When did they go out?
They went out mid to late August. I don't remember the exact date. I'll have to look that up.
August 17th.
It says August 24th or.
Yeah, just Mr. Reed, I would like, since this is such a, since this house is already on a tight lot and you are close to your neighbors and getting closer, I would like to get written support from your neighbors. That may mean knocking on their doors and showing them plans.
Okay. I did include plans and elevations in with the, as well as the plat in with the letters, and invited anyone to contact me. We have received 2 letters of strong support from neighbors, and I believe they were sent to Mr. Bowen as well as part of the supplemental material.
I see one.
I see 3.
Well, one was asking for a deferral.
2 are asking for deferral.
1725 North Culpeper is in support. 1836 North Culpeper is in support.
1836 I see, but that's the only one I see.
On the back side of the page is 1725.
1725. Which one is that?
17, North Culpeper is not even on the map.
Oh. All right. I was counting it. The Langston Citizens Association wants the deferral so that they can weigh in.
As well as the
Highview Park.
Yeah.
That's a committee. That's not a civic association.
Right.
Mr. Reed, I'm inclined to recommend that we defer this item so that you can properly contact your neighbors, and I mean knock on their doors and share with them your plans and get their input, as well as make arrangements to talk to the Civic Association and
Highview Park.
The Highview Park Committee.
I agree.
And my question is how long, right? Because if changes are going to be made, then 30 days is not going to be enough. Is 2?
It's got to be at least 2
Is that enough?
months.
Right, is at least 2, right?
Well, with the Highview Park and the Langston Citizens Association, they only meet once a month. So it's going to take, I would say, 2 months probably.
At a minimum.
At a minimum.
Does the applicant want to weigh in there?
Well, I don't believe the Ansaris are with us today, so I will need to discuss that with them. But it would be unfortunate to defer for 2 months, but that may be necessary.
Do the Ansaris live in the current building?
No, they do not. They outgrew the building some time ago. As I said, it only has 3 bedrooms and 1.5 baths, and they have a rather large multi-generational family.
Yeah, so either you or the Ansaris, whichever, you know, certainly if they're going to be the residents, they're having them meet their neighbors and might be an effective way of doing the outreach, but that's up to you.
Without them
Okay.
waiting, I don't know that we want to defer 2 months without their, do we want to defer 2 months without their consideration? Or, I mean, we have to vote on something.
Yeah.
I guess we'll defer 2 months, and if they decide they don't want to.
And if they can't make it, then they'll ask for a deferral.
Yeah, okay.
We're going to make a recommendation to defer 2 months, and hopefully you know, that will work with the Civic Association schedule.
If you could pass along to the Ansaris that they, getting in front of those 2 associations and the committee is probably important to get on their schedule because they only meet once a month. So time is of the essence if you want to get before them.
I'd like to make a motion.
Please do so.
In the matter of V-11770-22-UP-1, I move to defer this matter to the November 9th BZA meeting.
I'll second.
A motion has been made by Mr. Kaplan, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to defer the application to the November 9th BZA meeting passes 5-0. Thank you, Mr. Reed. That concludes this matter. Mr. Bowen, will you call the next case?
Yes, the next case will also be one of the cases that Meg researched and wrote a staff report for, so I will let her read the advertisement.
Case number V11771-22-UP1, a use permit request by Michael and Madeline Callahan. The owners to permit right side setback of 5.3 feet to the porch, 4.5 feet to the porch eve instead of 8 feet to the porch, 5 feet to the porch eve as required regarding after-fact approval for a rear screen porch on an existing one-family dwelling in the R8 zoning district on the premises known as 2914 John Marshall Drive in the Williamsburg Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And please note there is supplemental material.
And can the just supplemental material is just the revised disclosure statement?
That's correct.
What
was the
what has
difference?
changed? Yeah, I
what's the
was looking
difference?
for what's changed.
It looks like,
Oh, a second signature.
yeah.
Yep.
Second signature.
The one online is the current one that I have in my hand, so I can't actually tell.
Yeah, so that's the only difference. It was a second signature renotarized. Okay.
Can I see the one in the packet? Oh. Okay, totally new signature. Good. Also put my notary hat on. All right, are there any questions for the staff?
Sure.
Go.
Any background on how we got here?
I will defer to Meg if she knows. I can do some research on my side if needed.
I mean, this is an after effect approval, so we'd like to know how that came about.
Okay, I'll look into it. Do you want to move on to the next question while I look into that for you?
So that's not something you routinely look into? Why it was an after effect?
I can look. I don't remember offhand,
Okay.
but I can look.
If they were a corporation, maybe. Wait, right?
Madam Chair, if the applicant wants to go forward while Ms. Ryan is checking.
That sounds good. Is the applicant here?
I am here.
Oh, wonderful.
Good evening, everybody.
Hi.
I'm Michael Callahan. My wife Madeline couldn't be here today. We planned on Zoom, and I didn't realize that I either didn't have or didn't, I was supposed to sign up before noon and I didn't. Thanks for, thanks for sending that, Blake, but I was here already. And thanks in general to the staff for their help in raising questions and so I could respond to them. And thanks for your consideration. So how we got here, my wife and I have lived, the address of the property is 2914 John Marshall Drive. We've lived there since 1987. And this porch is our third structure in that exact same spot. We had replaced the deck when we moved. There was a deck there when we moved in. We replaced it. And then we decided that if we were going to spend time in the evening on there, the mosquitoes had gotten too bad and we needed to screen it in. So when we were replacing the deck and we wanted to turn it into a screen porch. And we talked to a couple of contractors about that. And as I said in my statement of justification, Whitestone Home Improvement did mention setback requirements and said he thought we'd be okay because I forget why. He said we'd be grandfathered, and I don't know if it was because the run of the building, the house itself was identical, or because we were putting a screen porch where the porch had already been. But anyway, he said, but you know, let's go ahead and you know, apply for a permit and ask. And you know, lo and behold, he came back and he said it's okay. So we built it. And then I must acknowledge that after we built it, he said, oh, there is a problem after all, and you need a variance. And, you know, I said, well, I was unhappy. I put, you know, I put it aside and I was going to get to that right away. And it just, I just forgot about it. It slipped my mind, life went on.
Maybe you wanted to forget about it. Maybe you wanted to forget about it.
Yeah.
I couldn't blame you there.
Yes, I guess. Not consciously, but yeah, maybe. But anyway, so that's how we got here. I hope that's satisfactory.
Okay.
Okay, so, all right, so we applied for variance, but it turns out what we need is a use permit, I guess because it's already there. And I did reach out, initially, not really understand the process. I only reached out to our neighbor, the porches in the back of the house on the north side. So I reached out to our neighbors immediately affected, our north side neighbors, and they said no problem, and I submitted it like that, and then I got a little education, and I went around to all our adjacent neighbors, and all our adjacent neighbors said it was fine with them, and they've all submitted written statements to that effect. And so physical characteristics, so the kind of laying out the case for variance, the physical characteristics of the property, I talked about. It's a porch on the back of our house that follows the line of the house, and it is within the setback requirements. Of course, that's why we're here. But it doesn't impair our neighbors at all, and they support it. And strict application of zoning requirements would prohibit or unreasonably restrict the use of development of the property. What? Just, am I out of time? No, that's the warning. Well, I mean, there's not really an alternative that I can think of, and so we'd have to, if you don't approve it where it is, I guess we'd have to tear it down or something. So we respectfully request that you allow us to leave it there, and that's basically it. And I'm happy to answer any questions you have.
Thank you. Anyone have any questions?
So just to clarify, and I know this will mean nothing to you after this hearing is over, but use permit standards are different than variance standards. And what you were reading was the variance standard that required that there be a hardship. The use permit standard, in fact, just says, is it compatible with your neighbors? And that's what this was evaluated on, is whether it's compatible. So you don't really have to prove a hardship in a use permit, just that it's compatible and not detrimental in any way. And so it's a lower standard.
Okay.
Thank you. I just mentioned that because you won't care about this when you leave here, but.
Yes, next time we won't put it there.
But I just, I wonder if staff, so you believe you had a building permit?
Yeah, we had a building permit.
And so that was issued in error? That's a question for staff.
I can do a little bit of research on that. It may not have been issued in error. A building permit may have been applied for, and then there was a rejection comment necessitating a BZA use permit due to the setbacks that were proposed.
But don't you get a building permit before you start building?
Typically, yes.
Do you ever wait till you build first, apply later? I mean, that's not.
Not best practices, but
No,
certain
it's not
contractors
what you
might,
do.
yeah.
Okay, you have your building permit.
He's got
Okay,
the building
you
permit.
got your building.
He came prepared.
You know, it's a little, it's coming up too often that.
Today, certainly.
That people are building things with, and then finding out that there's a zoning problem.
That seems like a builder. Lack of education.
Well, but I mean, there's a process where a project goes to zoning before that building permit is issued.
Yeah.
So if the builder has a building permit, he can presume that he's gotten
That's right.
signed off by zoning.
Yeah, absolutely.
So it was detected when there was an inspection? Is that when it was detected?
No, well, yeah, the final inspection, I guess, the wall check.
You did a wall check, and that's when it was determined.
Yeah. And that was after it was built.
I mean, I can speak from my personal experience when we did our kitchen, we were immediately sent to zoning, right? Like, do not pass go, immediately to zoning, right?
So.
Ms. Mallison, looking at our building permit records that at least I can access right now, I only see a building permit from 2010.
Yeah, that's the one in the tax records too.
Does your building permit have a number on it?
Yes. Well, I don't know, but it's right. That's when it was, 2010.
It's a 2010 building permit.
Yes.
Oh, so you really did wait a long time. I mean, isn't there a compliance issue?
Is that the building permit for the screened-in porch or for the deck before?
No, this is for the screened-in porch.
Oh.
So when was it? It was built in
It was built in
2010?
2010. Like I said, I forgot. And
But isn't there an enforcement action?
permit expired.
Ms. Malice, I may be able to chime in with some insights here. I'm not 100% sure this is the case here, but I know our colleagues in the Inspection Services Division who oversee the building code and the issuance of building permits, they have been dealing with some older building permits that were not closed out properly. This may be one of them, and in order to close it out, there might have been an inspection that was necessitated that found that the setbacks were non-conforming.
Makes sense.
So that is a possible theory. I'm not 100% sure that's correct, but I do know that that has been going on with our colleagues in ISD this year.
So they're asking us to bless their mistake.
Yeah, I'm trying to just think it through. So what triggers the wall check?
The final, I assume a CO, right?
But for a screen porch, is there a CO? What triggers the wall check? I'm just trying to understand the sequence here.
I don't want to speak in terms of the overall building permit process, since it's not a zoning process exclusively, but a wall check survey is typically required at the close of construction or as before framing begins to make sure that the setbacks are compliant. And that way the building would not progress too far if the walls were found to be non-conforming to the building permit standard at that time.
So when was the wall check done?
2010.
Well, yeah, 2010, after
completion,
was built.
not when the.
Well, I don't know when it was done. That's when I was told. I assume that's when it was done.
I don't know that I would have a memory of 12 years ago with the
Yeah,
specifics
this is-
either.
Yeah, all right, so very old mistake.
I think that's an understatement.
And then when did somebody prompt you to come before us, or did you just turn yourself in?
I got an email from zoning
Recently?
saying your permit's expiring. I talked to them. I figured out what happened.
Got
They
it.
said, we want to do a wall check, and I said, well,
It's not
Got
going to
it.
pass.
yeah,
All right,
train's
all
left.
right. Well, I hope you didn't lose a lot of sleep over it.
Are we ready for a motion?
Yes.
In the matter of V-11771-22-UP-1, I move that the Board of Zoning Appeals adopt the attached proposed resolution approving the use permit. I did that backwards, but that's okay.
A second.
A motion has been made and seconded. A motion has been made by Mr. Kaplan, seconded by Ms. Clark. Is there any further discussion? All right, I will call the roll. Ms. Freshman.
Aye.
Ms. Clark.
Aye.
Oh, Ms. Malice, sorry, I went out of
Aye.
order. Mr. Kaplan.
Aye.
Chair votes aye. The motion.
Finally, an approval.
The motion, right. The motion to grant the application passes 5-0. I would say enjoy your deck, but you've been doing that for a while.
Well, thank you. Well, thank you very
Getting a
much
little
for your
punchy.
consideration.
We are getting a little punchy.
You can rest in peace. I'm going to call my wife as soon as I get out the door.
Thank you.
Thank you very much. Thanks. Thank you, Blake.
All right, that concludes this matter. Mr. Bowen or Ms. Ryan, can you please call the next case?
Sure. The next case on the agenda is case number V11772-22-UP1, which was approved in the group motion. So the next case following that is case number V11773-22-UP-2, a use permit request by Michael and Kathleen Cahill, the owners to permit a side setback of 4.3 feet to the wall, 3.8 feet to the eave, instead 10 feet to the wall, 5 feet to the eave, as required regarding new addition to a semi-detached dwelling in the R27 zoning district on the premises known as 3533 22nd Street South in Green Valley. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And we have not received speaker sign-ups or additional supplemental materials.
Oh, I thought this one was on the consent, was it not?
Yeah, it was.
Yeah, this one was on the consent agenda.
Wow. 7-3? No, it wasn't.
It wasn't?
No, not 7-3, unless I wrote my notes wrong.
Oh.
No, we did not have that on the consent agenda.
Okay.
Item number
But
8
but that was
we're on item 9.
772 that she was reading.
Right, item 8 we passed, we're on item 9 now.
All right.
Am I mistaken?
I think I wanted this one on the consent agenda.
It was recommended, but we didn't put it there.
All right. Does anyone have any questions for the staff? All right. Mr. Cahill, would you like to speak?
Hi, everyone. Thank you, Blake and Megan. Definitely appreciate your support. I'm happy to answer any questions, but the plastic shed that you see there is essentially the location of the proposed 12 by 24 lean-to. I think in the update that I had made in late August was a garage. There's going to be a garage door at the front, and the siding would essentially be the same to match existing. I did attempt to physically go and outreach all the neighbors surrounding, and was able to get signatures, with my proposed plan here. And I'd be happy to answer any questions. I think that the setback is, it's abutting South Langley Street, which originally was the deck, was the line, the property line that I was applying for when I did the deck in 2016, and then come to find out it was actually the closest rear corner where that use permit was was granted and not South Langley Street. But this setback is for the property line, South Langley.
I think it's important to note for the record that South Langley Street is not an actual road that is used.
Yep.
It's not.
It's not.
It's not abandoned either or vacated, but it still exists, but there is no way to drive down it, so it seems like a rather strange setback.
Yeah, I mean, I cut the grass. Like I cut the grass on the other side of my fence. So that's the setback in question.
I think this was not on the consent because of the, at least in my view, of the driveway issue.
Which driveway issue?
That the plot didn't note the driveway issue, that there was a driveway and they would have to go for further approval. There's a note on the bottom of page 2 on the staff report. So it cannot be used as a garage without further process through Arlington County.
So you were going to put a garage door on the shed
Yeah. Yes.
to drive something into it?
A vehicle could fit in the proposed structure. Yes.
Can you go back to the picture with the, I guess it was showing a shed that was there, but there's a fence around it?
Mm-hmm.
There is. The
The
fence is
previous
actually,
one did, yeah, that one.
Yeah, that fence extends all the way back to the property line in the back.
And then you would have to extend the driveway to drive.
So on the proposed, I revised the plat, and essentially that corner from the driveway, the existing driveway would be gravel. My intent is not to do any type of concrete pad or foundation. It would be very simple in nature. I mean, clean in nature, but I wouldn't be pouring any hard concrete.
So you would open that up to be able to drive through?
On a diagonal, yeah. I think I wasn't going to cut any curb. So my intent is not to cut any curbs. Everything is existing, and in order to access the new portal at the door, I would be laying gravel.
Question for staff then. Regarding the note here, what would have to happen for the applicant to be able to drive a vehicle into this structure?
So from a zoning standpoint, if this was to be used as a garage and it wouldn't have a driveway leading to it, I believe a likely course of action would be if it were, found to be being used as a garage without a driveway. It could be a situation that would open up our applicant to a zoning in violation. However, if a driveway is put in subsequently, which, would very, very unlikely require BZA relief for setback issues or anything, then there would likely be no violation if there is a driveway put in subsequently.
So does this lean-to conform to the requirements of a garage?
So that particular issue would be analyzed by our colleagues on the zoning plan review team. But I can take a quick look and give some initial thoughts at least. And if there's any other questions, please feel free to ask, and I'll do a little bit of research on that question in a moment.
I guess the picture you have shown with the garage door there, that's for a regular car to fit in, or?
Correct.
Looks small, but.
Yeah.
And that's your plan, right?
Correct.
Yeah.
Well, actually what's in the driveway is what I intend to put in the shed. It's really, that is my purpose for this design. But yeah.
And to put your boat in.
Yeah. I mean, that tower folds down.
Is there a difference in parking a boat versus a car? Right? Is that the same requirements that we're talking about here?
Yeah.
Don't talk about.
I will say that I do not ordinarily assess boat parking, so I don't want to answer that question on the spot.
So you're still working on the garage question?
Correct.
Okay.
Right, but that might change the analysis if we're, the intent is not a car. Arlington County may or may not care about a boat.
Well, it's still driving something in there.
Right, I don't know. I'm saying I don't know, right. Right, what's the point of our approval if Arlington County is not going to approve that?
Seems like maybe the horse is before the
That's
cart.
chicken or egg, right?
Horse is before the cart, cart is before the horse.
Chicken or egg?
What would be your height of the structure you're building? Because it looks like it would extend much more than the one that's there.
So it's going to be 12 feet at its highest point.
12 feet at
and
the
it
highest.
will lean down. It's a lean-to, so it will just be at an angle from.
What does lean to? That it just slopes down from the house?
Correct.
Okay.
But the fencing around it would
The
not.
fencing, so the fencing on South Langley Street will remain. That fencing there will remain. The fencing at the front will obviously come off, and the door would be moved. The pedestrian door would be moved so that I can access the backyard on the side.
So is it going to go all the way to the ground, the lean-to?
No.
No, it
No.
stops.
No, it will extend 12 feet to the South Langley Street property line. And then down.
Ms. Malice, to answer your earlier question, looking at the plans, it looks like we have a depth of 24 feet and a width of 12 feet. I believe our zoning ordinance would allow parking in this as a minimal standard. It meets those. The minimal standard is typically 8.5 feet in width, and let me double check. Yeah, 8.5 feet in width and 18 feet in depth.
Which looks like that's small. That's probably what's already there. So this opening, garage opening, would be bigger.
The garage opening is going to be a standard. I think I put it in the plan. It's going to be the largest standard that comes in from like Home Depot or Lowe's or anything. I think it's like an 8x9 or I think it's 8x9.
So the staff report refers to it as a dwelling. Is that maybe a misnomer?
Yeah.
Yep, a new addition to a semi-attached dwelling.
Oh,
I mean,
the semi,
dwelling.
a new
Oh,
addition to the semi.
Yep.
Yeah.
To a semi, a new addition.
It refers to it as an addition.
Addition, just an addition.
It is, to clarify, it is 8x9, the garage door.
Question for Ms. Malice.
Ooh.
Do you have thoughts on an approval with a condition subject to DES approval? Or
Well, somebody had to review this already for a driveway because I had a slanted horizontal driveway on my BZA approval. So how did they weigh in on the driveway situation?
Yeah.
It doesn't show a driveway, does it, on the plans?
No, that's true.
Plans don't show a driveway, so it wouldn't have been.
Because I didn't actually own my driveway.
The BZA approval itself would not require the driveway to be built since we're only looking at the setback to the building wall. The driveway could be included in a subsequent building permit submission. And since it's not, and very likely is not above 8 inches above grade, it wouldn't require zoning review or approval.
my concern is that we would be approving a structure that the applicant wants to use for a purpose that's not yet approved and will likely be approved, but that approval is not yet and would require further approval by the county.
So use is dictated by the zoning ordinance, right? This is for sale. Use is dictated by the zoning ordinance, but we're having to get an approval on the driveway before it can be used as a garage.
Well, the driveway is not technically even it's not in the drawing, so they're not really even asking for it.
Right. My concern is that we're being asked to approve a garage that's going to be used for a garage, but cannot legally be yet used for a garage until further approval not related to our purview has to be granted.
So I think it's being called a structure. It's not being called a garage right now, correct?
That's true.
It's not being called a garage. I was questioning whether if it became used as a garage, whether it would conform, but right now it's just a structure.
Do you agree?
Yes, and we typically, or maybe I shouldn't say typically, but we very often see building permits that don't necessarily even require new constructions just to reanalyze an existing building for a new use. So that could be something that is incorporated into a subsequent building permit review.
So we're not approving a garage.
Right.
Fair enough.
We're approving the structure.
We're approving
Okay.
the structure. So the question is, do we have anything to say about any subsequent decision to use it differently? And you could argue both sides of it, but I mean, you could make a condition that if it becomes a garage, but I think the fact that we're just approving a structure, and is the structure approvable, and then the county can decide whether to grant the driveway. And my concern was just that if that's what you wanted it to be used for, you didn't want the county to then say it doesn't conform to being a garage.
I think that in the last submission before we the package was finalized, the question came up is like what you need to define the square footage that you're going to be taking for the drive path. And so that's when it dawned on me that any type of driveway was going to be any type of consideration for this. So I'm happy to do whatever I need to do.
You may have a second step here, but I think we can approve the structure.
Yeah.
Yep.
Knowing that it could be used for a garage, and what happens next is up to
Okay.
staff and the applicant. But it's an interesting situation. The little note.
Right. But like I said, it was why I did not recommend it. For the
Me
consent.
too.
Right.
I totally thought that it was. I park in front of this house, to your house every day to go to drop off my kid at school.
Madam Chair, I'm happy to make a motion.
Please do so.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11773-22-UP-2, subject to the conditions listed.
Second.
Thank you. A motion has been made by Ms. Malice and seconded by Mr. Kaplan. Is there any further discussion? I'm going to check with our colleague. No hand. All right, I will call the roll.
Still with us?
She is.
We don't see her all the time. There she is.
No, I see her. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
The chair votes aye. The motion to grant the application passes 5-0. You're all set.
Thank you very
Thanks
much.
for hanging around.
Thanks, Blake, Megan, thank you.
Thank you.
That concludes this matter. Blake or Meg, can you please call the next case?
Yes, Ms. Arthurs, the next case is case number V-11774-22-UP-1, a use permit request by Skylar Aarons on behalf of James McDonald, the owner, to permit a minimum separation of 2.3 feet between the eave of the accessory building and the eave of the main building instead of 4 feet as required, regarding a new detached garage with eaves and columns on a lot with an existing one-family dwelling in the R6 zoning district on the premises known as 4040 20th Road North within the Cherrydale Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. Two alternative resolutions with conditions have been provided should the BZA see fit to approve the application as advertised or with a minimum separation of 3.7 feet. Please note that there is supplemental material for this case that came in after the applications packets were assembled and printed, and this includes an updated statement of justification as well as an email from the applicant, including several attachments and photos.
All right. Any questions?
I have one for staff. What is the policy rationale for separation between the house and the outbuilding?
Ms. Malice, do you mean in terms of the specific distances that are given or just,
Right.
Okay. So accessory buildings of a certain size, and that's in this district, that have a footprint of 560 square feet or less, and also measure 1.5 stories and 25 feet or less, can be as close as 8 feet to the main dwelling. In addition, the zoning ordinance has a general allowance for building eaves to encroach 4 feet into required yards. So therefore, 8 feet minus the 4 feet encroachment for eaves is the 4-foot allowance we list in the advertisement.
And do you know the policy rationale for that separation? Is it safety? Is it?
Imagine it's like fire code.
Partially, I think it's based in the fire code. Generally, the fire code has a 5-foot separation requirement between buildings, so I think it's partially informed by that. And then just a whole lot of our zoning regulations are based on bulk and massing and keeping the buildings separate from one another and keeping yards and open space on the lot.
Okay. Thank you.
Anyone else have any questions? All right, Mr. McDonald, would you like to speak? I see that you're with us virtually.
I am, and I'm not sure what the protocol is, whether I should have Skylar speak first or if I should speak first as my agent.
I can go ahead and start, and then Mr. McDonald can chime in afterwards. Share what he has. First, I'd like to thank staff for their work on this. Usually, I try to get a favorable staff report whenever we have a BZA case, and that's usually my number one goal. I understand, obviously, the board makes all the final decisions, and but we do try to work to get support. And I do apologize for the late documents. I didn't even notice that statement wasn't updated. It actually didn't even necessarily pertain exactly to this request, because we found out about this request after we submitted our use permit request. We originally thought we were asking for requests for the side setback of the proposed rear porch, and then found out it was actually okay with the side setback, and in fact there was a separation issue. And so I think with the recent change in the system, the permitting system and data system, I think there was some type of glitch or something didn't get uploaded. And I've actually dealt with that a lot on the permitting side. So, so it's not uncommon the last couple of months. But nonetheless, I just wanted to make sure that was updated. Again, it's really unfortunate that we didn't get support from staff on this one. The structure really is kind of the last thing they can do on this property. They're trying to preserve a lot of space in the back, and they're meeting the criteria of the zoning ordinance with everything else regards to setbacks as far as side setback, front setback, and rear setback. And then the separation is really kind of the only issue. Even in lot coverage, they're kind of at the maximum, and in reality, another resolution to this would have been, hey, can you just put this all the way back? Well, two things. One would be a lot coverage issue. The other would be a land disturbance issue, where they probably have to do a grading plan and kick them into a higher land disturbance, which would be pretty difficult to deal with. Lastly, they just really want to preserve as much green space. They don't want to pave over most of the lot. So really, this placement is kind of the only suitable place for it to work. We've talked about we could possibly jostle it up a few inches or a foot or so, if need be. But the owner was trying to kind of prevent this kind of flat block look on the front and kind of have some contour by setting back a little bit. So we're just really trying to preserve a lot of things, architecturally, green space. I will add, from a fire code perspective, I do a lot of plans and permits. Generally, a garage only needs to be separated between the garage and the habitable space by 1 hour separation, which is usually only like a 1/2 inch drywall. I would say separation, I think more or less, a lot of times they say is a 5-foot width of the property line. But it's kind of strange because, in Arlington, you can build these structures up to 1 foot away from the property line. And then you just have to have some type of fire rating system on that wall going along it. I don't necessarily think there is a fire rating or a fire concern with the particular situation of separation. The existing area, the part of the house that there is a separation concern is really just a roofed area that's covering an areaway. It's not even really a habitable portion of the house or even like a porch. It's just some area that covers. And I think as much as I've been hearing a lot from some of these hearings, sometimes I think it's a blessing kind of being the end of the night here, because you get to hear a lot of examples and some of the concerns that come up from neighbors. And I think flooding, you know, in some of these areas, it's great to have a covering over your areaway, especially when you have this kind of paved area or concrete solid area that where water can just get dumped into your basement. I told him the owner agreed it was probably not a conveniently placed areaway. He obviously did not build this. It was here prior to the owner purchasing the property. But it does serve a good purpose, I think, for covering that areaway. You know, there's other alternatives too. Again, this porch is kind of a necessity because they want to house a lot of things in there, and more particularly house them out of sight from the front view. You know, I think technically we could almost build a lean-to roof structure between the garage and main building, and that would kind of, I think, architecturally would look bad, but something they could technically do by right. And I think this kind of helps prevent doing something that prevent them from building something by right that may not be as architecturally appeasing. So yeah, sorry, I'm trying to cram a lot in there because I got a short time here. But I can go ahead and leave the rest of the time up for Mr. McDonald and what he would like to contribute.
You're giving him 5 seconds.
Thank you.
I'm from New Jersey originally, so I'm a fast talker, but I don't know if I'm quite that fast.
Madam
Well,
Chair.
from a homeowner's perspective, first and foremost, thank you guys for taking your time this evening. And I have been an Arlington resident in this home for the past 12 years. I have 3 school-aged children, and our preference would definitely be to keep them in the only home that they've ever known. But the truth of the matter is that our family has grown, and this house has become a little bit restrictive in terms of both storage and living space. And in contemplating this project, we really did focus not only ensuring that we had the room that we need to increase our living and storage space, but as Skylar was saying, we do also want to make sure that we can continue to enjoy our yard and maintain green space in the neighborhood. I intend to use the space above the garage as an office, and in allowing the project to move forward as we proposed, that won't only allow us to do the things like store our garbage cans and our grill out of sight and out of the rain and the snow. It'll also allow us to enjoy our yard more and also to move back and forth between the garage and the house with minimal exposure to the elements, because in using that as an office, it will be a pretty much daily occurrence going back and forth between the 2 structures. Pragmatically speaking, as Skylar was saying, we are limited in where we could build this because in addition to the limitations created by the setbacks and the lot usage, our home has an environmentally friendly geothermal heating and cooling system, including 2 240-foot deep wells in our backyard, which we cannot disturb. If I understand Mr. Bowen's report correctly, we've pretty much aligned to all of the zoning requirements with the exception of the one issue before you today, which is a difference of a precedence of 3.7 feet compared to our proposed distance of 2.3 feet between the eaves. And on page 4 of Mr. Bowen's report, he does acknowledge that the 4 other properties they're using as benchmarks for the recommendation are based on plats which did not specify the eave dimensions or the setbacks, so the measurements upon which the county is relying are taken wall to wall between the main building and the accessory building. So as such, I believe that Mr. Bowen was unable to confirm if any of the properties demonstrate an eve to eve separation of 2.3 or less. So I guess I have questions on the validity of the precedents that we're currently relying upon. And as Skylar did point out, it is really important to note that the eaves in question are not habitable structures. There's simply that small roof over the egress stairs of the basement and the proposed porch on the back of the building. And ultimately, our perspective is that the county indicates the only concern for the proposed detached garage is that it may not promote compatibility of development with the surrounding neighborhood because the placement would not be similar to structures on the property surrounding the subject property. But from our perspective, the proposed project would allow us to preserve the character of this 1923 home rather than pursuing a more aggressive project such as a complete remodel or a tear down rebuild. We do have the support of 10 neighbors that have endorsed the project, including every adjacent property. And we ultimately do want to come to an agreement with the county that helps us enjoy the project as intended. And we do look forward to hearing your decision.
Thank you. Does anyone have any questions? Ms. Mouth.
So the issue is the roof of the covered porch or the columns of the covered porch and the roof over the areaway. Are those the 2 things that are in conflict?
Well, yes, the separation. I would say the 2.3 and forgive me, let me just pull up the plat here. I think the 2.3, which is the most extreme dimension, that's the distance between the eaves themselves. If you were like walking under that area, the difference would be 3.3 feet actually between that beam and post and the adjacent structure.
So here's the difficulty always is, you know, when we go lower, we set a precedent. And often the rationale for the precedent doesn't ever comes through, because in this case, when we're talking roof to column, it's very different than building to building, right? We're talking eaves.
Yes.
But yet, you know, once we approve this, next time something comes up, staff will just say 2.3 is the new standard. I'm not saying that that's going to prevent me from approving this, but that is always the difficulty, is that the particulars don't convey with the knowledge down the road that there was an extenuating circumstance for making that change. Staff has offered a 3.7. Have you evaluated that?
I've spoken with staff and the owner about it, yes. As far as deciding whether that's something that works, I would leave that to the homeowner. You know, I didn't know possibly there's some type of compromise in the middle. Yeah, I'm not sure. I guess the only thing, I know sometimes a precedence is set, but I just feel like I've done this long enough where I feel like we've been told in the past that a precedent doesn't always mean everything. You know, a case is taken by case scenario. And so I get that. I also do get that a precedent can be something that is something that adds to the validity of a future case. I don't know. I just feel like we're in such a modern era now where this thing is so, the T's are so crossed and the I's are so dotted that they'll be able to look at the staff report and see the particulars for this case. If staff wanted to say, hey, this precedent existed, but really it was because of X, Y, and Z, not, you know, so that two houses could be built 2 feet apart from each other. So that's just my rationale behind it, my take on it, of course.
Anyone have any other questions, thoughts, motions?
No.
All right, someone say something.
It is what it is.
Yeah.
And and I appreciate the constraints of the project. You know, what's the garage width?
16.
Does is that
The width is 16.
is the garage width negotiable?
It makes it very challenging because of the stair situation. Whenever doing these 1.5-story garages, the stairs always become kind of a sticking point, kind of an issue, trying to just making it all work dimensionally. Width is very challenging. The depth also, you know, believe it or not, for as shallow as the garage is, it should be able to fit quite a few different types of vehicles. I think even the vehicle that Mr. McDonald owns possibly fits. Just saying that because we can't sacrifice anything on length and depth.
And maybe I'm not understanding this correctly, but what if you moved the garage forward? Wouldn't that solve your problem?
You can't see him. What was the question? I'm sorry.
If you move the garage forward, wouldn't you get more separation?
I mean, is it a matter of, and I'm just spitballing here again because we're in the middle of the hearing. Is it possible the board would accept if we moved it forward a foot for a 3.3 separation?
Yeah, so there was a reason you wanted the garage set back from the front of the house?
Yeah, just a little bit of, so it wasn't just kind of a flat look, and they had a little bit of contour in the look there in the front. The existing front of the house is non-conforming. I mean, again, we can move it up a foot or so, but again, I would leave that to the homeowner to make that final decision.
So I guess you're looking at a hypotenuse here. If you moved it up a foot, what would it give you?
I don't think it's going to give them that much.
Ms. Ryan, can you bring up pictures of this?
Of the front of the house?
Yeah, the front, to start with at least. Is there any ground level front for me?
That might be the best one.
Oh, 40, 39.
So the garage is.
And, you know, again, I don't know if it's just the sheer, again, precedence and looking at numbers for what they are. You know, it's really not something that's even visible, I think. I feel like as far as the distance in the two from any perspective, really, unless you were just standing back there and kind of looking at it.
No, I think we're.
From our perspective, I think we were eyeing it up, and I think like a foot or so would definitely be okay with us. I think what we're trying to avoid is having definitely the garage start being further forward than the front of the house. And I think that a foot would pretty much put them even.
If we move the garage a foot forward, does that help enough that we could manage an approval?
That would be it. Right. Sorry, then we'd be at 3.3, which is closer to what the staff was recommending.
That was your calculation? Oh. Good.
And there's probably a possibility to cut that corner. Right, we're just worried about that corner, correct?
Yeah, for the covered patio.
Right, so if you cut a sliver out of that corner, then there's no issue.
Unless you make the patio like unusable that you can't even put.
But just in that one corner though.
Yeah.
I'm nervous about establishing the precedent, like
Yeah,
we were
that's the
talking
only
about.
thing
I'm
is
really,
that-
because we're not going to get the details in 3-4 years. Staff's just going to have a report that says 2.3 or whatnot, and then that's the new standard for the entire neighborhood.
Mm-hmm.
Mr. McDonald, can you weigh in on moving it forward? Or
I
did
believe
you
you
and
said 1 foot would be okay.
You did. I'm sorry. I was trying to figure
Yeah,
something.
I would be fine. I think what we were really trying to avoid is having the garage, the front of the garage in front of the house.
Right.
Where it looks like it's starting to encroach. And if my memory serves, moving it forward 1 foot would pretty much have them be flush with one another.
It looks like there's about a foot to spare, right? So the current is at 27 to the wall. The house is at 23.7.
It's more than a foot. Yeah, more than a foot.
Right, so it's more than a foot. So you have a foot and a half to spare, or 2 feet from there.
Yeah, it's a slight, I know it's a slight accommodation, and it probably doesn't seem to make a lot of sense to you to move, to quibble around about inches, but when these things become precedents, it concerns.
So would 3.3 feet work if we slid it toward would the board be more comfortable with 3.3?
I think we would. Ms. Freshman has her hand up. Do you want to weigh in?
Well, as I look at the drawing, it seems that what we're debating is, or maybe I'm misreading it, the difference between the covered areaway and the covered patio.
Mm-hmm.
That's right.
And I would rather get rid of the patio than move the garage forward. I don't think it should be closer to the street, and I don't think it should be aligned perfectly with the house. I think it looks fine the way it is. I think my solution would be not to set a precedent, but to not have a covered patio. If the desire is basically to have a garage and office space, that can be accommodated. And that would be the direction in which I would go. And moreover, I would say that if you start moving buildings around, you can't approve something when you don't have commit drawings that show what you're approving, and that would mean a delay.
If I may, we did contemplate that, and really the intent with the patio is a couple of different things. One, we do want covered space where we can put a grill, where, you know, we could also sit outside in the shade as the kids play in the backyard. And that is, you know, really from our perspective, an integral part of it, but it also just does allow us a little bit of freedom to move back and forth between the two buildings instead of running back and forth in a torrential downpour when I'm going back and forth to work in the office as well.
Well, there would be a door on the backside of the garage anyway, right? But to the patio?
Correct.
So, yeah, it's difficult. Ms. Freshman raises a good point. It gets difficult when we start making design, decisions or suggestions here without redoing the drawings. But I mean, if the purpose of the covered patio was to act as a shelter and also, a grilling area, maybe the depth could be less. That's another way to shave off a foot. Because you do have, I think you do have a screened porch, so you have a place to watch your kids where they play, right?
It is, but with the elevation and given the positioning of it, I mean, we are, you know, they're not in line of sight, let's say.
So I think we're reluctant to prove it at the lower number, and we're grasping for suggestions. And
What about making the covered patios smaller?
yeah, I mean, that was my suggestion.
Oh,
was
sorry.
Just making it, a foot, instead of moving the garage, make it 5 feet instead of 6 feet. But I'm having trouble proceeding with anything besides a deferral if we're starting to talk about changing the drawings.
I think that's right. And I think, to me, like just looking at this, if this were mine, I would just, cut that corner and make a 2-corner edge there. And then, you could easily get a 3.7 there by taking about a foot off of that corner, a 2 foot by 2 foot chunk out of that corner.
So,
I guess it's just the garage is already kind of sitting back over the required setbacks. I didn't know why moving it forward was not a good idea instead of taking away from the structure. I mean, we're still meeting the setback requirement if we move it forward a foot, and the owner's still kind of getting the design features he wants. I understand kind of working around and cutting corners, but I think architecturally, sacrificing some things archicturally.
Yeah, either way, right.
Yeah. I mean, trust me, I
was just having a suggestion.
A lot of things like that in the past, but with something like this, it seems like it's a small give to make something kind of, quite frankly, just look unattractive. I think in that corner.
I can appreciate that.
And we can definitely, again, I think the homeowners expressed we're happy to move this thing forward a foot, and it still stays beyond the setback requirement. We won't be encroaching. We'll still be offset from the front, and kind of still gives that offset and contour we were looking for, so that's not just one flat front feature. It's tough. I get it. And I don't want to be the one who sets a precedent either for anything smaller than that. And, again, if everyone could pallet just moving it forward a foot, I don't think that really changes anything design wise per se. It just says we're moving it forward a foot from what it's shown on the plat. That and the plat is also done by the surveyor and everything, so it's not like Arlington's great where they'll allow you to submit a plat that isn't necessarily brand new, but this one is brand new. This was done for this project, so everything should be laid out correctly.
So the applicant's preference would be to just move it forward a foot?
Correct. And then you'll have a separation of 3.3 at the eaves and 4.3 at the main structure itself.
Mr. Bowen, do we need new drawings for that?
If this case is to come back to a future BZA hearing, we would probably need to reevaluate a drawing set. However, if the board is comfortable approving a setback of greater than 2.3 feet, so if we move it forward a foot, I imagine we'll get to a 3.3 feet separation. That is a greater separation than has been advertised, so we could approve it tonight. So I think it would come down to your comfort level and how we write the condition language for it.
Yeah, because
Right.
usually we refer to the drawings.
We do. We need Mr. Melnick. He loved doing this.
This one is probably, it's literally, it's a box, right?
Yeah.
So we can probably craft, if everyone is comfortable, we can probably craft a condition regarding it, or we could defer it and wait for a new plat.
Are we pretty sure the number is 3.3?
Yes,
Well,
it has to be.
It has to be. If we're moving it a foot, it's 2.3 right now. That's what they're asking relief for.
Not a hypotenuse, it's just.
No, it's a straight moving.
It's a straight moving.
Correct.
Okay.
Yeah, and the front dimensions are provided also, so you just say, it's 26 and
That's right.
27, 25 and 26, so.
Right, we could refer to the plot and move the front setback to the wall from 27 to 26, from the eave 26 to 25, and approving a column to column as 3.3.
Column to column would actually be 4.3. It's the eave is what would be 3.3.
That's what.
Oh, right.
Thank you.
Right.
Yes.
Right.
Yeah, which is a better condition, when most of the time the eaves are kind of overlooked in most of the zoning stuff, but as long as the principal structure meets, so.
Madam Chair, since Ms. Freshman raised the issue of drawings, maybe I'd like to know if she's satisfied with proceeding without new drawings.
I guess I will agree that if it's as simple as you make it sound and the condition puts all of the numbers in.
Okay.
This instead of that, this instead of that, this instead of that. I think it's got to be very specific in order to be substituted for the drawing that in 99 cases out of 100, we would insist on.
Okay.
It's about 3 numbers. Here.
So we would be starting with alternate resolution number 2, making that 3.3.
With alternative number 1 or 2? Number 2.
And then.
So it would be 3.3 feet between the eaves and the accessory dwelling and the eave of the main building instead of 4 feet as required.
And then changing the text in the last whereas. And.
To 3.3.
Right.
You see that?
So.
What page are we on? What page are we
on? Page 8.
Page 8, I believe.
8, okay.
So in condition number 1, the applicant agrees that detached garage shall be constructed in accordance with the proposed footprint on the survey. We would say 1 foot forward of,
Towards the street.
1 foot towards the street. Can we be that plain, Mr. Bowen?
If you give me like 5 minutes, I'll come up with language and have specific numbers.
Okay.
Instead of moving 1 foot forward, I can give you each of the 4 different numbers.
Let's do that. Would you guys, can we do that? Can we just hold off for?
We're going to table you.
Yeah, we're going to table you. We're going to go to the next case. Mr. Kaplan's going to get the language that we need exactly, and then we will vote on this after the next case, if that's okay with you guys.
Yeah. Yes, thank you.
Okay.
Can I just ask a question?
Mhm.
Are you amending the first whereas or therefore in this resolution to because it references the
Yes.
staff report?
Yes.
So
Yes.
would you be,
Condition
is that
number
where you
1.
would put in the new numbers?
Yes.
Yes, with
Okay.
and it'll either be an additional sentence or 2 on that one or a 5th condition. I'm going to write it on my computer.
Got it.
Yeah, it's a good idea to write it and then also give it to staff.
That's
good
yeah.
call.
That's why I want to go on to the next one, and I think the next one will be a long one.
All right. Thank you, guys. We'll be back with you after the next case.
Thank you.
All right. Mr. Bowen or Ms. Ryan, can you call the next case?
Sure. I'll note that the very next case is case V-11775-22-UP-1, which was approved in the group motion at the start of the hearing. So I'll move past that to the follow-up case, case number V-11776-22-VA-1, a variance request by William Blackwell on behalf of Brian Vahali and William Jones, the owners, to permit a maximum lot coverage of 54.3% instead of 48% as required regarding a new in-ground pool to an existing one-family dwelling in the R6 zoning district on the premises known as 520 North Jackson Street within the Ashton Heights Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the variance. An alternative resolution with conditions has been provided should the BZA see fit to approve the application as advertised. I'll also note that we have additional speakers who have signed up to speak on this case, as well as supplemental materials that were received after the application packets were printed and assembled. These supplemental materials include 10 neighborhood outreach letters, and we also have heard from the applicants for this case requesting deferral.
On this case?
Yeah.
On North Jackson?
On
North Jackson?
Yeah, it came in this morning. All right.
Oh, I missed that.
We have a lot of speakers. All right. Are the applicants here or online? Okay. How about Mr. Blackwell? All right. Well, do you guys have any questions for staff?
I do have questions
Oh,
for staff.
are you guys here?
We're opposed. We're neighbors.
Okay, so.
Mr. Joyce, Mr. Grace, Mr. Carpenter? Whoever.
Okay, just.
I'm Mr. Grace.
Okay.
Are we going to do questions for staff or are we going to see?
Yeah.
Okay.
We're going to do questions for staff first. Anyone have any questions?
So.
I don't love that the applicants aren't here.
The applicant is not here, is that correct? And they've requested a deferral?
They've requested a deferral.
It's someplace in this pile of papers.
It's
how far back?
It's pretty far back. It's an email from Angela Helton. I don't have page numbers. I can't really help. It took me a while to find it. Are you in the supplemental?
Yeah. Oh, it's
the supplemental.
It's in the supplemental.
Mhm.
Yeah, that's where I'm still trying to find it in the supplemental. They've requested. So this is the case with the swimming pool?
Yes.
All right. The applicant is not here, so since they've requested a deferral, that's what we would do even if, yeah, you know.
Well, no matter what.
Either way, we would do that. But my question for Mr. Bowen is, you discussed this application with the applicant and informed him that you could not support it.
Yes, prior to the staff reports being printed for the BZA, we send drafts to the applicants when the reports are done.
And did you have a conversation explaining to the applicant what our powers are? The justification seems to be that they don't agree with the ordinance.
Yeah, Meg and I did not have that discussion to my knowledge. I believe they may have spoken to some of our colleagues in the zoning division instead of us.
Because just to start off with, you know, the justification is that they don't agree with the ordinance. They think it's confusing. It is not in our power to overrule the ordinance. I mean, that as a starting point. So I just wondered if the applicant understood what our powers were.
And they have requested a follow-up meeting after this hearing, assuming deferral is granted, where we'll talk further on those points.
Okay. All right. Well, would you guys, one of you guys like to speak? Who would like to go first?
I'd like to. I mean, you know, by the way, thank you, Blake, for your help, and certainly, we've been sitting here for 3 hours. I'm glad, I mean, you're doing God's work. I mean, I don't know how you, once a month, 3 hours, I mean, that's just too much. I could hardly deal with this emotionally for the last couple of months. So,
Could you identify yourself for the
so
record?
here's the deal.
Could you
So-
identify yourself for the record?
Oh, I'm sorry. I'm Peter Joyce. My wife, Barbara Freer, is here. We live directly next door to this property at 516 North Jackson Street. We've been there for 29 years. We rented a house around the corner for a year before we were able to buy this house. So that's who we are. Bruce Grace is here as well. We submitted 2 fairly detailed letters. So knowing it's late, I don't want to go into a lot of details. And in addition to that, we conferred with the Arlington Heights Civic Association. Scott Sklar has submitted an email that was not part of the supplemental packages that I could see, but basically saying the position of the association is that ordinances are rules, and unless there's a real hardship, they should be adhered to. And we agree with that as members of the association. And then we have a total, I guess, of 7 comments of neighbors directly in the area that have all voiced opposition to this idea. So I think there's 2 points to it. The first point is rules are rules, right? I mean, in the years that I've lived here, we pay our taxes, we pick up after our dog, we do all the right things. And so we think rules should be upheld. And it's very clearly stated in my mind from the ordinance that no in-ground swimming pools are allowed, given limited lots and standard coverage. And then it goes on to say that, a reasonable deviation can be applied if it results in unnecessary and unreasonable hardship to the homeowner. I'm sorry, I don't think a swimming pool is a hardship. The second point I want to make is the fact that this area has had a history of water problems, both runoff drainage and groundwater issues. And when the house that was there prior, which was fairly modest, was sold, I knew there was going to be a larger house put in. And so we did a bit of research, and I was shocked by the fact that, about 64,000 gallons of water come off the roof annually, given Arlington's 43 inches of rain a year right now. And we know it's increasing. If you multiply that times the 5 or 6 houses in the area, I mean, that's almost 400,000 gallons of water. It's got to go somewhere. The other thing that an expert has described to me is when you put a foundation in the ground or a cement swimming pool, it's like building a Hoover Dam. And somewhere there's going to be a miniature Lake Mead as a result of that. So what we did at the time of the building of this house to be proactive, we decreased our coverage. We eliminated our garage. We tore up an asphalt driveway that we had that went the length of the property. We installed a permeable, smaller parking pad. We put in a French drain, and we installed rain barrels. I mean, my wife tells me I'm learning to compost now in Arlington. I mean, it sounds crazy, but we decreased our coverage, So I just think the ordinance is clear. The idea is not to increase coverage. We just can't handle it. And it's not just about the neighboring houses. We know the groundwater system is problematic. Almost every one of the cases that came up tonight, most of them all had to do with water. So a swimming pool? So I guess, I think that's the main thing for us as a group. And I'm going to leave it to Bruce if he wanted to add, or someone else, or if you have questions for us.
Are there any additional speakers?
Oh, by the way, one last thing. Since they deferred this thing, because I don't want to be upset about this, but my understanding is the application went in March. And then in June, in passing, there were plot stakes put in the ground. And we asked Bill, the neighbor, we said, Bill, what's up? And he said, I don't know. We're talking about putting in a pool. I don't think it's going to happen. That was the discussion. And then in July, we got what was supposed to be a registered letter. We were away. We were staying in Massachusetts. Our neighbors picked up some mail to bring to us. The registered matter, the certified letter was there. We never signed for it. And so I don't know what all the little stickers in there, I don't know who actually got it and received it. And then in August, we got the letter from you all. So this has been up and around for quite a while. And I just think that, oh, by the way, when we got the certified letter, we were in Massachusetts. We called them and said, what's up? And they said, oh, we don't think this is going to happen. And that was the end of the discussion. And then when we got the letter from the county, I know this is dragging out. We got the letter from the county. They were away at the US Open for the week. I called and said, can we talk? And they said, well, we're not back to the 12th. I said, the hearing is the 14th. I said, can we speak today at some point? And so they said, okay, how about sometime between noon? So we called them to have a discussion about this. And it was clear that they were going to fight this to the end because they felt like that's what their boys needed. So anyway, that's the communication thing. So you can see how upset I am because we get here, we're here on time, we're playing by the rules, and they're deferring after that crazy
You need to speak
list of
in the mic.
communication. Okay, probably better I didn't speak into them.
All right. Anybody else want to speak?
Hi, thank you very much for all your attention. I won't speak for very long. I'm Bruce Grace, 521 North Kenmore Street. We're the property right behind. And I think I submitted a letter and I point out that the pool would be, very close to our property line. We just have a lot of problems with water. I mean, our backyard is inundated. When it rains, we've got water on the surface for days. So that's why we're opposing it. But it seems like you just can't put a pool in. So this seems a little bit academic, I think. So, but thanks for your attention. I am a little surprised that the owners didn't let us know that it was going to be deferred tonight.
Yeah.
But
The letter, I guess.
I won't
came
say
in.
anything else, but I am a little bit surprised
9:20.
that we didn't do that.
You what?
Thank you.
Yeah, the letter came in at 9:20 this morning, right?
Okay, you found
Yeah.
it?
Yeah, it's on the back of this.
Oh, okay.
All right, let's,
Does that conclude the speakers?
yes, I believe so.
We do have Mark Carpenter noted as present virtually. I'm not sure if he's here.
Mr. Carpenter, are you on? All right, given that it's 10:10, we're gonna, Mr. Carpenter's not speaking up, we're gonna move on. Can someone make a motion?
So here's the thing, I'm reading the deferral. I wish the applicant were here tonight because I would not move a deferral.
I agree.
I mean, I guess that my question is there support for anything other than a deferral? Because the applicant had an option to be here and chose not to be here.
So that's it. This becomes not a legal question, but a practice question. It has been our practice when the applicant does not show to give them a chance to remedy that. But
then we're also noticing and spending all of our time and our staff again
and
to do this again when they didn't show up.
Right. So I would, I guess, ask Mr. Bowen to let the applicant know that we will act on it the next time it is on the agenda, regardless of their presence.
Yes, we will, per the request, we will plan to meet with them after this hearing and we can communicate that they should be present.
I think it may be possible that it could be withdrawn.
I have a 20-second comment for the record in case the applicant chooses to listen to this. But criteria number one, would the strict application of the terms of this ordinance unreasonably restrict the utilization of the property? I don't think we can meet that, right? Number two, I don't think we can meet that. And then the biggest one is number three, the condition or situation of the property is not so general or reoccurring as to make reasonably practicable to formulate a regulation which can be adopted as an amendment to the ordinance. Well, in this place, clearly, if the Arlington County Board would like to rectify this for the applicant, they clearly could and allow pools to be built in ignoring the requirements.
Yeah.
So I don't think they can meet any of these.
So I think we all know how we're going to vote once they actually show up.
Yeah, we always give the applicant a chance
Fair
to
enough.
make their presentation, and that's why we have a hearing.
Fair enough.
But I think the misunderstanding to me is in the applicant's justification where he feels that the ordinance is unfair or misconstrued.
Which
or-
very well may be, but we have nothing to do with.
And that is something that we cannot give relief on. We are not, that is an issue to take up with the county board.
Could I read something that they submitted to us regarding the ordinance and their approach to it?
Not really.
I think they said it in their justification letter. Normally I would say yes, but we absolutely need to move on. We very much appreciate you being here.
And so you're basically deferring it, or will they get a decision by you, Blake?
So,
No, so we're deferring it to next month so that they have a chance to appear, but I think it's evident. Well, I think it's evident from the conversations up here that we all know how we're going to vote.
Well,
but
we don't
need
know.
to hear
We
from
don't
the
know how we're
applicant.
gonna vote.
We need to hear from the applicant.
So is there any way to find out what they say to Blake in this little private meeting they went?
No, I can't imagine that would.
No, they
no.
don't have to share that. It's everything that happens, as far as we're concerned, the board is concerned, will happen in public. Staff can talk to whoever they wish, but we won't talk to anybody except in public.
If this helps at all, you can join via Teams and throw it on your phone and you don't have to come back here.
I mean, obviously, we came
Because you were good citizens and good neighbors.
what this is about, because we pick up after I go. This is about rules.
Moving
All right, we
on.
got one more case.
All right, thank you for your time.
Thank you guys for your time. All right, who would like to make a motion?
I would like to just say something for the record.
Oh, yes, please.
Who is that?
I would not be opposed to denying it on its face. But I also say, as this is the first time in history when there has been a virtual option, I think it's arrogant to assume that requesting a deferral, perhaps because of neighborhood opposition, that the applicants or an agent did not even make the effort to participate virtually. I understand that it's always been our tradition when somebody doesn't show up to just defer it without knowing the reason, but there have been ample opportunity to at least listen in and chime in at this point. So I believe that there would not be support for a denial, so I'm not going to waste your time, but I wanted to make the point.
Well, I think to further that point, the application is dated, there's notarized in March, which I believe you said. So how long has staff been working on this application and going back and forth with the applicant?
In terms of the time that it's been with us, I don't believe we've had it since March. It just probably came as a BZA application in March, after March, but it may have been something that went to our colleagues on the zoning plan review team for a building permit beforehand. And I'm sorry to say I'm not specifically familiar with the history starting in March.
Madam Chair, I'd like to make a motion.
Okay.
But before I do, it's possible. So I'm going to make a motion for a 1-month deferral, but this is for you all that came. If it's withdrawn, you just have to look at the agenda. Do we still do a withdrawal motion? Or
Our
put it on the
policy
agenda?
for withdrawals, as of perhaps it was the July meeting or maybe perhaps the June meeting before that, we kind of just do an administrative thing where we acknowledge the withdrawal and reread the case number.
Does it?
That's
Is
right.
it appear on the agenda?
It does.
It does.
It does. So for you all, you would just look at next month's agenda to see if this case is on here as an active item or by any chance it's been withdrawn. If it's been withdrawn, it's over.
You also will receive notice though if they receive notice the first time of the hearing as neighbors, right?
They'll get another round of letters?
Because we have to
Correct.
renotice
Yeah.
everything again.
Okay. So, but if it's a withdrawal, they don't get another round of letters?
If it's on the agenda, it should be, right?
Depending on when it's withdrawn. If it's withdrawn before we do our notices, you might not get a notice. If it's withdrawn after we do the notices, we would update probably our staff report and our recommendations in the attached materials.
Okay, so we could still see the day of that it wasn't happening.
Yes.
Yeah, and
The
feel
agenda
free
will-
to reach out to me as well with any questions.
The agenda will come out the Friday before the hearing, so you can also check the website anytime before then.
And if they make any written presentations, are those available to us?
Staff report.
Yeah, it'll be in
Online.
the staff report.
You know, I used to be a high school teacher, and one of the things that always had happened is somebody raised their hand and say, do you mind if I take the test, you know, next week because I have this party or something to go to? I mean, my concern is they've got another month. I don't get it. They get extra time? Is that what happens? You know?
Well,
we don't
nothing-
have extra time to go back and, you know, we worked hard over the last few weeks to talk with our neighbors. They didn't talk to us at all. And I listened to the other cases and I say, many of the cases you listen to, those were neighbors that did the right thing in terms of trying to work communication. That's not what's happening in this case. And, you know, it's a blatant, you know, request to go against what's the rule. And so I'm finding it very hard to understand how they get extra time. To be honest with you,
They gain no advantage by deferring this a month, believe
I
me.
would say it's really kind of, I think someone used the word arrogant to just not show up.
I agree.
We have to give applicants the benefit of the doubt. You know, we don't know the circumstance, so we can't prejudice our thinking without knowing what's going on.
but I do think Judy made a very good point, and that is in the virtual world, maybe those rules need to change.
We don't know what the circumstance
Yes.
is. You know, we don't know why the applicant's not here. We don't know.
Thank you, guys.
Thank you for staying for 3 hours for this.
Well, no, our thanks to you. It's an impressive bit of civic involvement.
Thank you.
Kudos to you all.
Thank you.
Thank you.
All right, motion.
Good, I didn't make a
Meg.
motion.
Oh, I did some research. I looked in our permit Arlington and they started the application May 6th and we accepted it in July. Just for a little background on it.
All right, well,
All right.
July,
Whatever.
August, September.
All right.
No.
Madam
it's still-
Chair?
Yes.
In case V-11776-22-VA-1, I move that the Board of Zoning Appeals defer this matter to our October 12th hearing.
A second.
A motion has been made by Ms. Malice and seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Freshman.
No.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Judy, you threw me off. Mr. Kaplan.
Aye.
The chair votes aye. The motion to defer the application to the October 12th BZA hearing passes 4-1. Totally threw me off. All right, that concludes this long matter. Let's go back to our friends in the previous case, Mr. McDonald. If you guys want to turn your screens on, you're welcome to. Mr. Kaplan, would you like to make a motion?
I sure would like to make a motion.
That is fabulous.
Is the applicant still with us?
Yes.
There they are.
Oh, hey, guys. Okay, great.
Mr. Bowen advised me to read the entire motion, but I think in the interest of time, I'm only replacing numbers in the first half, and I will read the condition I'm changing.
Fabulous.
So we're going to split the baby. Okay. Yeah. I move that the Board of Zoning Appeals approved the altered attached proposed alternative motion.
Alternate number 2.
Number 2.
Number 2, correct. I was getting there as I was scrolling down.
We're jumpy.
The changes I am making to the whereas clauses is anytime there is a 2.3, that is changing to 3.3. There are 4 of them.
There's one in the resolution title,
1 in the resolution title,
2 in the last whereas,
yes.
and 1 in the first condition.
Wait, 2.3 to 3.3, or there's 3.7 is the
All the number, yeah, and the 3.7s are changing to 3.3.
Yeah. Everything
Right,
just moved.
The 2.3s are changing to 3.3.
Nope.
The 3.7 is 3.3.
Alternative resolution 2.
Yeah.
Right, so in the first whereas, to permit a minimum separation of 3.3 feet,
Right there.
right? So that 2.3 is changing to 3.3?
Hey, let's just read it.
Okay, sorry.
Let's just read it.
I apologize.
No worries. Let's just
Okay.
be clear and let everyone go to bed.
Okay. Whereas the Board of Zoning Appeals, BZA, has held a duly advertised public hearing on September 14th, 2022 on case number V-11774-22-UP-1 to permit a minimum
So I'm sorry, that one doesn't change because that's what was that's the advertised language.
Oh, thank you.
Correct, yeah.
So that one is
That
stays.
Thank you. I did not realize that.
Okay, but then we're going to say, but we're going to change what we advertised.
Okay.
So there's no change until we get to the last whereas.
The BZA
Correct.
has determined that the
Okay.
modification.
Okay. So what should I do here? Should I start?
No, we'll piece it together. All right. The first whereas clause in alternate number 2.
Unchanged.
The first 4 stay unchanged.
Correct.
Start reading the fifth.
The fifth one, whereas the BZA has determined that the modification is compatible with the development in the surrounding neighborhood, provided that a separation of at least 3.3 feet is maintained between the building eaves and the accessory building eaves, and that the structure's overall footprint, size, and placement are similar to comparable structures on other properties surrounding the lot in question, provided that the separation of at least 3.3 feet is maintained between the main building eaves and the accessory building eaves, and the proposal would help preserve natural landform, historical features, and/or significant trees. Now, therefore, be it resolved that the BZA hereby approves special use permit case number V-11774-22-UP-1, subject to the following, and I'm going to strike the entire number 1 and read number 1. Read the new number 1.
Great.
The applicant agrees the detached garage shall be constructed in accordance with the proposed footprint shown on the survey, and that the architectural drawings attached to the staff report dated September 9th, 2022, with the exception that the detached garage shall be constructed with a front setback of 26 feet to the wall, 25 feet to the eave, instead of 26 feet to the wall, 27 feet to the eave, as noted on the proposed plat, and that the footprint may not be enlarged, and that the setbacks approved by the BZA may not be reduced from what is shown on the attached plat and/or architectural drawings, with the exception of the separation between the main building eaves and the accessory building eaves, which must measure at least 3.3 feet. And the remaining conditions remain unchanged.
That sounds good to me.
I second that.
Great. Motion has been, well done. A motion has been made by Mr. Kaplan, seconded by Ms. Malice. Is there any further discussion? Great, I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
The chair votes aye. The motion to grant the application passes 5-0. Thanks for hanging in there with us, guys. We appreciate it.
Everyone on the board, thank you. Thank you to staff. Thank you to everyone. Thank you. Y'all have a good evening.
Thanks, you too.
Thank you.
Good night.
All right, that concludes this matter. Mr. Bowen or Ms. Ryan, can you please read the next case?
Last case.
Let me check where we are on the agenda since we jumped around a little bit.
Yeah, I'm kinda
We
confused
have
too.
I
done-
can
We're on
read the next
14.
one.
Okay,
So the
thanks,
next
Meg.
case, V1777-22-UP2, was approved in the group motion. So the next case would be case number V-11-778-22-UP2. A use permit by Robert Munier, the owner, to permit a left side setback of 6.2 feet to the wall instead of 6.5 feet as previously approved regarding a modification to the BZA use permit V-11498-19-UP-1 for a construction area of a side addition in the R6 zoning district on the premises known as 743 North Albemarle Street in Bluemont. Staff recommends that the board defer the application to the October 12, 2022 BZA hearing.
Oh, wait, they want to defer?
Yes.
Great. I hope no one else
Madam
applies
Chair?
for any new applications in October because we're not going to have any space.
Yes.
Or we'll just sleep here.
Madam Chair,
Yes,
I'd like to make a motion.
please do so.
In case V-11778-22-UP-2, I move that the Board of Zoning Appeals defer this matter to the
October 12th.
October 12th BZA hearing.
I'll second.
Fabulous. Motion has been made by Ms. Malice, seconded by Ms. Clark. Any further discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Clark. Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to defer the application to the October 12th BZA hearing passes 5-0.
You're getting good at this.
I have a cheat sheet that I still use. And I write in who makes the motions. It works. Last case, who would like to call it?
I will. Case number V-11779-22-UP1 was approved in the group motion at the beginning.
Scared me.
I was gonna say,
I
I
was
have
gonna say,
another.
I don't got it anymore.
Love it. All right, let's do some minutes. We have two. Oh, right, August 12th. Anyone want to make a motion on the July minutes?
I'll move
Make
approval.
I don't have it in front of me.
Oh,
Hold on.
Judy, you want to do it?
Yes, I'll move approval of the July 13, 2022. Do we have to do them separately?
No, let's do them together.
Can't do it
August,
together.
Can't do them together, sorry.
oh, sorry.
And just says no.
Oh, because I can't vote on both of them.
Oh, fair, okay. July.
That's why I say no.
Okay, July 13, 2022 minutes.
Wait a second.
Second.
A motion has been made to approve the minutes by Ms. Freshman, seconded by Mr. Kaplan. I'll call the roll. Ms. Freshman.
Aye.
Ms. Malice, you were here, right?
For the 13th.
Yes. Okay, Ms. Malice.
I'm an aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. Motion to pass the minutes passes 5-0. Someone give me July or August.
I move approval August 12, 2022 BZA minutes.
Second.
A motion has been made by Ms. Freshman to approve the August minutes, seconded by Mr. Kaplan. I'll call the roll. Ms. Freshman.
Aye.
Ms. Malice is
Abstaining.
Abstaining. Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. Motion to approve the minutes passes 4-0 with one abstention. Anyone have anything else?
Bye.
Let's conclude this meeting. See you guys. Thank you.